Today we will hear from the Attorney-General, the Honourable Jaclyn Symes MP. This is the sixth day of the hearings in Hearing Block 5, where we are primarily hearing from government witnesses on the priority areas of child protection and criminal justice. I have a long-standing commitment which requires me to leave at 1 p.m, and I'm grateful if the Commissioners do continue after I've gone. But I would like to make some opening remarks today, given the importance of this historic Royal Commission and the historical significance of having the Attorney-General with us engaging in truth-telling before the country's first Aboriginal-led Royal Commission. The Attorney-General's role occupies the position of First Law Officer. However, this authority is derived from the contested colonial project in Victoria since 1851. Aboriginal people's law and law, LAW, have governed the land and our people for thousands of years. First Peoples have lived in land-owning clan groups from representing the longest continuous living cultural tradition in the world. The government's own submission acknowledges that the establishment of the state of Victoria in 1851 brought with it widespread land theft, decimation of culture, removal of children and enforced poverty. For us, the past is the present. The word protection has been with us since 1838, the Port Phillip Protection. The Board of Protection began a series of boards which have been in our lives since 1860, and we have conversations about child protection using that same word, protection. The board itself was replaced by a welfare board in 1957. This is a long chain of history that our families have experienced, and in my own family, my great-grandparents, both great-grandparents, were moved from different sides of the state under this legislation, and only one of them died in their own country when they passed. Violence, racism and denial of self-determination continued under these laws. At this moment of historical significance, there is a choice to be made. The government can choose to listen to the hard truths emerging from the Yoorrook Justice Commission, and they are hard truths. They are hard to hear, and they take a toll on our people in terms of trauma and the continuous exposure to having to talk to this space. The government can choose to make change. I believe it is now a time for reckoning with the past and creating a new future together. Commissioner Hunter, may I ask you to do the welcome country?
Thank you, Chair. I'd like to acknowledge that we are on the land of the Wurundjeri and pay my respects to elders, past and present, not only mine but those of all the nations within Victoria. I want to acknowledge the stolen generations. I want to acknowledge those that didn't make it home, those that did, and those still searching. And to those who died at the hands of the state, I'd like to acknowledge those. Can we please all stand for a minute's silence? May we never forget them. You can be seated. Thank you.
Thank you, Commissioner Hunter. Counsel, may we have appearances, please?
May it please the Commission, Chair. My name is McAvoy, appear as co-senior counsel assisted by my learned juniors, Ms. Sorrella Fitzgerald and Mr. Tom Rawlinson.
Thank you, Chair. My name is Gray. I appear again with Miss Sarah Keating for the State, and in particular for the Attorney-General. We wish to acknowledge that we meet today on Wurundjeri land and we pay our profound respects to Elders past and present, and we pay our respects to Aboriginal or Torres Strait Islander people who are here today or who are listening in. Thank you.
Counsel. Thank you, Counsel.
Chair, there's one administrative matter to deal with before we move to today's witness. I should add that there is only the one witness, the Attorney-General, today, and we will have further witnesses on Monday. The Commission has received an updated version of the Attorney-General's witness statement. That document is identified as DJCS.001.0001.0066_R.
Thank you, Counsel.
And we seek to tender that document, which can then be made publicly available.
The document will be allocated the next exhibit number.
Thank you, Chair. Now, if the Commission pleases, I now call today's witness, the Honourable Attorney-General, the Honourable Jaclyn Symes MP.
Thank you and welcome. Welcome.
Thank you so much. It's an honour to be here. I'd like to provide an opening statement, and I, of course, would like to begin with acknowledging the traditional owners of the lands of which the historic meeting is taking place today, the Wurundjeri people. I pay my deep personal respects to Elders past, present and emerging, and I extend that respect to all Aboriginal people, people that are here today and people who may be tuning in. I'd like to acknowledge the importance of Collingwood and Fitzroy, where we are meeting today, as a place of rich Aboriginal community-led activism and leadership. I'd also like to acknowledge the Tanarong people as the traditional owners of the country in which I live and where I'm raising my children. I pay my respect to Tanarong elders, and particularly those that I've been fortunate to meet and build relationships with. I also acknowledge that this is and always will be unceded Aboriginal land. I am truly humbled to appear before the Yoorrook Justice Commission today as the Attorney-General. I particularly want to thank the Commissioners and staff. Your dedication to this process is evident and you are exercising your duties with purpose. But I know that this week in particular, Block 5 has touched on many topics that have huge emotional impact for Aboriginal people, and I want to acknowledge that I know your job is not an easy one. As First Law Officer, I personally acknowledge nearly 2 centuries of dispossession and colonisation of Aboriginal people and the role that the legal and criminal justice system has played in this. I hope my evidence offers value to the historic truth-telling process in making sense of these very difficult truths. I'm planning on being open, frank, and hopefully useful to this Commission. I also expect to learn from the process, as I regularly do when engaging with Aboriginal stakeholders, especially the AJF and its members. As Attorney-General, my role includes upholding the rule of law, a key principle and foundation of existing systems of law and government. I recognise, however, that although the rule of law means equal application of the law, in practice this has not been the case for Aboriginal people, which is undeniably evident through data and poor justice outcomes. The Uluru Statement from the Heart is profound and beautiful in its language, but the one sentence or 2 sentences that are entirely gut-wrenching to me is, proportionately, we are the most incarcerated people on the planet. We are not innately criminal people. I come today recognising that there is a crisis when it comes to justice outcomes for Aboriginal people. In doing so, I acknowledge the death of Veronica Nelson, Michael Suckling, Heather Calgarrett, Joshua Kerr and Clinton Austin, who have passed in prison since January 2020. And I also regularly reflect on the tragic passing of Auntie Tanya Day. I acknowledge the profound impact these deaths have had on families, friends, and the wider Aboriginal community. In preparation for today's hearing, I have personally reflected on the criminal justice system, the structures of government and government decision-making, and their significant flaws. Sometimes government doesn't get the balance right, and sometimes we don't make the right decisions. Clearly, there have been too many instances where the law-making processes or the application of those laws have failed Aboriginal people. I acknowledge that many in the community, including the Commission, rightly consider that the pace and scale of the just and necessary change has been too slow. But I do appear before the Commission today with a sense of urgency in this critical moment in history, which I hope will be a breakthrough, a turning point for us all. I cannot change the past, but I can certainly acknowledge past wrongs. I can vow to do better, to listen, to learn, and to engage and enact meaningful change. To this is acknowledging structural racism. It is both overt through the data and disguised in its operation. Structural racism that has been inherited from our colonial past, that is undisputed through many stories heard in the Commission and told extensively through the Aboriginal Justice Forum. I acknowledge that both conscious and unconscious bias still exist in individuals and is still prevalent throughout the justice system. Its persistence is unacceptable. These are all failings that are not unique to the justice system, but permeate through every level of society, and we should be ashamed that they still exist. I am proud to be part of a government that is committed to work together with this Commission and the Aboriginal community to create a future that's based on respect, empowerment and self-determination. For too long, Aboriginal communities have been denied their right to self-determination through the dispossession of land, the denial of culture, and very often the silencing of voices. I do recognise that self-determination is not just the correct thing to do, it's a fundamental right of Aboriginal people. And inherent to self-determination is the right of Aboriginal people to define for themselves what self-determination means. We are still far from achieving self-determination in the justice system, but we are starting from a really strong foundation of 23 years partnership, working with and being led by Aboriginal communities through the Justice Forum and the caucus, and more recently with the First Peoples Assembly. The government will be guided by the truth told at Yoorrook and the findings and recommendations that the Commission will make. I do appear today with optimism. I hope that truth-telling can lead to healing. Most of all, I hope that non-Aboriginal people and Aboriginal people can continue to walk together as we build a new relationship through treaty. I'm here to assist the Commission and I welcome your questions.
Thank you, Attorney. Chair, is there to be any further comment at this point?
No, not.
Thank you. Attorney, I will now ask some questions. You've prepared a statement which has been tendered this morning in response to a notice to produce. Yes?
Yes.
In that statement, if you've got it in front of you, do you?
I do.
Paragraph 7 on the first page, you acknowledge that the justice system has both recently and historically been a site of exclusion and oppression, whether through laws that were specific... Oh, sorry. Before I go any further, I need to make sure that you're going to tell the truth. And,
we should do that.
I ask, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do.
Notwithstanding 2 reminder notes, I moved straight past that very important piece. So I'll just take you back to paragraph 7. There's an acknowledgement at that paragraph that the justice system has both recently and historically been the site of exclusion and oppression, whether through laws that were specifically targeted Aboriginal peoples, laws that were unequally applied to them, or through the refusal to enact specific laws for the advancement of Aboriginal peoples or engage Aboriginal peoples in the design of laws that affect them. I acknowledge that this has resulted in entrenched systemic and structural racism within the justice system and the broader institutions of government. You can see that. It goes on. I acknowledge also that the impact and structures of colonisation are far-reaching and intergenerational and are continuing to affect Aboriginal people's interactions with the criminal justice system. And it is in the context of that acknowledgement and others in the beginning of your statement that you are giving your evidence today on behalf of the Victorian Government.
I am.
And in your role as Attorney General for the State of Victoria, you have certain responsibilities, ministerial responsibilities, including with respect to the Charter of Human Rights and Responsibilities,
I do.
the Bail Act,
Yes.
the Sentencing Act,
Yes.
the Crimes Act and the Summary Offences Act.
Yes.
And you also have responsibility for the courts, the Independent Broad-Based Anti-Corruption Commission. Yes?
Respecting their independence, I have
Yes.
administrative responsibilities. Yes.
And similarly for the Ombudsman.
Correct.
And so these are all matters you accept that are extremely pertinent to the criminal justice inquiries that this Commission is undertaking.
Yes.
And in terms of your own experience, is there anything that you can say, particularly looking at paragraphs 13 to 20 of your statement, about your background and what you bring to the role of Attorney General?
In terms of my background, I was appointed as Attorney General in December 2020. I've been a Member of Parliament since 2014. First was made a Minister following the 2018 election and was appointed to the roles of Agriculture Minister, Regional Development and Resources Minister. And in addition to the Attorney General portfolio that I hold now, I'm also the Minister for Emergency Services. I have a long-standing background in justice. I'm a lawyer and I previously started my, career in government as an advisor to the former Attorney General starting in 2015. So I've had direct responsibility for justice policy as an advisor for a period of time, then I guess a bit of a break into different policy areas and have returned to justice.
So it is the case that some of the long-standing reform issues you've had a previous responsibility or engagement with?
Certainly knowledge of, various degrees of involvement with before becoming the Attorney General.
Now, the acknowledgements that you've made here today on behalf of the State of Victoria, I suggest are significant, and the words are perhaps words that many people would never have expected to hear from an Attorney General, even maybe a decade ago. However, they appear to be consistent with a government that has listened to the First Peoples of Victoria when they demanded fundamental change in their relationships with the state. You'd agree with that?
I do.
Would you agree with me, Attorney, that the broad change in government as is occurring through these treaty and truth-telling processes is rarely linear? By that I mean that some parts of government move more quickly than others. Some issues are more amenable to resolution than others, and there may not always be a uniform shift in direction across the whole of government. You would agree with that proposition?
I can acknowledge that, yes.
But even though this is the case, that doesn't mean that there shouldn't be strong action where there's urgent need.
Agree.
And you said that in your opening.
Yep, absolutely.
Nor should there be every effort made to oversee consistent change across government. Would you agree with that?
I do agree with that.
You're aware that the Victorian government has entered a negotiation framework with the First People's Assembly of Victoria?
Yes.
And under that agreement, negotiations towards a statewide treaty may commence this year.
Yes.
You're aware of that? And consistent with the commencement of those negotiations, you're aware that the Aboriginal Justice Caucus has called for a self-determining justice system for some time?
6 years, yes. Well, sometimes 6 years since government and AJA agreed to it.
And looking at paragraphs 60 and 61 of your statement, are you able to perhaps give the Commissioners some insight as to what your understanding of a self-determining justice system is for Aboriginal people in Victoria?
I can try, because it's a very difficult question to answer. As we know, self-determination is a principle that government certainly supports, and Aboriginal organisations and stakeholders have been talking about it for some time, and how that it can bring about meaningful change. Self-determination is a feature and a desire, and indeed a commitment under the Aboriginal Justice Agreement. Self-determination was first agreed with government and Aboriginal Justice Caucus 6 years ago. Defining what Aboriginal self-determination is something that I shouldn't do. What I acknowledge is that self-determination for Aboriginal people must be led, determined and defined by Aboriginal people. But what I do know is that it is not just handing over everything to Aboriginal people and saying, you know, you fix it. It requires a meaningful partnership with government to ensure that self-determination principles can be respected, enacted and have meaningful effect for Victoria.
Thank you for that. I've noticed through the various witnesses, many government witnesses have said that it's difficult to actually say what self-determination is, and it's up to First Peoples to determine that. But having said that, it's really necessary for both sides to actually have an agreed position on what self-determination is, and perhaps more importantly, what it isn't. So are there any moves to actually come to, because it's not much point if First Peoples have a definition of self-determination if that's not agreed on the government side and the sides have different ideas of what it looks like. It sort of seems to me a recipe for chaos.
I think it's an evolution of exploring where you can embed self-determination principles in policy. For instance, when I ask the exact question of members of the Aboriginal Justice Caucus, you know, what does it mean for self-determination for you? How can I help enact that in my portfolio? A practical example is, well, rather than government determining which policies are best to receive funding, how about you allocate the bucket of funding to Aboriginal-led organisations and let us determine which are our highest priorities? Government shouldn't do the cherry picking. We understand that there's limited resources, but leave us to determine which is best for our people, which could be different in different locations across the state, which I think is a really good example of, yes, I would much prefer Aboriginal people to tell me what is a priority for them rather than hearing from government what we think is best.
You mentioned the word meaningful partnership before. Can you just explain what you mean by meaningful partnership?
Yeah, I think what I mean by that is that consulting for the sake of talking isn't meaningful partnership. Going to a group of people with a predetermined outcome and consulting with them, getting their views but not acting on them is not true partnership. So for me, true partnership, particularly in policy development, particularly in the way I approach my work is getting in and having conversations early so that my policy development process is informed at an early process, having meaningful engagement that is reflected in outcomes as opposed to trying to convince someone of your position when it's been formed without them.
And under treaty, where there's been advocacy from caucus and our people for a long period of time around self-determination. So under self-determination, and why I asked the question around partnership is, at the moment, community doesn't have authority in the partnership. It ultimately sits with government. So under treaty, reimagined system, something different. You're talking about true self-determination. What does equity in partnership look like in a self-determined context?
Oh, that's a really good question. I really, really value the input from Aboriginal Justice Caucus and the members and the forum. And I leave quite excited each time I've left those meetings, because there's purpose and there's things that we want to get on and do. And that's the structure that I'm working within. And I add a lot of value to that process. But I acknowledge that ultimately the decision is of government, it is of cabinet. And I think that the next iteration of what that forum looks like, how it fits in with treaty, will be a great opportunity to explore some of the issues that you've raised in terms of greater capacity to influence the final decision making, not just the creation of it. I think is something that I'm particularly interested in. The next steps of what AJF or treaty and how they work together is going to look like.
Thank you, Commissioner. Attorney, in your statement, you acknowledge that there's not much in the way of guidance from other jurisdictions in Australia as to how self-determination is given effect in the criminal justice systems. I might observe that in part that's because the work here is at the forefront of that particular level of reform. But I wonder whether, Attorney, you're aware of material that's the work that's being done in New Zealand in this space. In particular, I'm referring to a referral to the New Zealand law reform body, the Law Commission, which has received a referral to examine the relationship between and to develop a framework for engagement between tikanga Māori, which is Māori law, and the New Zealand laws, including the common law. That work, it seems to me, might be something that this government could do in the context of Victoria, to help develop a better understanding of the relationship between Victorian Aboriginal law and the Western law that exists. Is that something that's been brought to your attention before?
It has, but I'm not across the detail, but I've certainly been interested in what they're doing in New Zealand. I know that they were a good influence in relation to even the setting up of this process. Looking to other jurisdictions obviously is a good way to learn. I am interested in exploring more what they're doing in New Zealand and whether it can be of any benefit to Victoria.
So built into the question I've just asked is a presumption, I suppose, that self-determination in the criminal justice context is not just about doing things and programs, but about understanding and knowledge. And there's work that could be done in that realm. You would agree with that?
Yeah, I would. I think there's opportunities to build on things that we have here in Victoria, and if you can learn from other jurisdictions, absolutely.
I want to take you now to the issue which you've touched on in several places in your statement, and you've touched on in your opening remarks, and you cover those matters at paragraphs 36 to 42 of your statement, and that is your comments with respect to systemic racism. Now, in those paragraphs, if I may try and paraphrase it, you address some of the issues relating to systemic racism in the justice system, and you accept that systemic racism exists in the present day as well. But I don't see in the statement a connection between racism that occurred, has its origins in the British invasion of First Peoples countries. Now, you did make some mention of that in your opening statement, but it's not in your statement in as such an overt form. Can you confirm for the Commission that the state of Victoria understands that from at least from Aboriginal people's perspective, and it's been well recorded, that systemic racism has its origins in the arrival of the colony on their shores?
Undisputably.
So, do you accept that in the colonial period, the prevailing way of describing Aboriginal people was to describe them as subhuman, to deny human dignity and status to Aboriginal people? Do you accept that that's what happened in the past?
Yes, that's the factual reality of the history, yes.
Sorry?
That's factually correct, yes.
And this served the purpose, we know, of assisting in justifying the theft of land without compensation and the dispossession of Aboriginal people in Victoria?
That amongst a lot of other horrible behaviours, yes.
Do you accept that this willingness to disregard and discount Aboriginal people's rights and interests flows through in the organisational culture to the present day in government agencies?
Look, I think structural racism, as you've put it, absolutely has its foundations in colonisation. And for me, and I touched on it in my opening and in my statement, there are certainly structural racism that persists today. For me, that is most evident in the outcomes, in the numbers, in the disproportionate impacts of the justice system on Aboriginal people. And there is a lot of factors for that, but certainly structural racism is certainly a leading cause.
And some of that is what was complained of by Aboriginal people in the cultural review of the adult custodial correction system. You agree?
Yeah, I agree with that, and also through a lot of the hearings that you've had here at the Commission.
You also accept, though, that those same sentiments which underpin the structural racism may consciously and unconsciously affect decisions by persons exercising governmental power in relation to Aboriginal people?
Sometimes.
So, to be more direct, there are many discretionary powers that government officers of all varieties exercise in relation to Aboriginal people, whether it's making some decision in relation to the safety or welfare of a child, whether a person is drunk or whether a person ought to be is a bail risk.
Yep.
And that there may be conscious and unconscious racism that comes into those decision-making processes.
I think that's true.
The question I have now is perhaps a more difficult one. How does a colonial government, such as the Victorian government, confront and eliminate one of the elements upon which it was built?
Well, I think through processes such as this, through truth-telling, through acknowledgement, through acceptance and apology for years and years of poor behaviour that's been underpinned by racism, and understanding that you need to proactively consider reversing that. You need to think about how you can change your policies and processes in conjunction with meaningful engagement with Aboriginal people about how you can do things better and, in fact, differently.
With respect, Attorney, it hasn't happened to date that those changes have been made. This isn't the first time that the issue of structural and systemic racism has been raised. It was one of the underlying features in the report from the Royal Commission into Aboriginal Deaths in Custody some 32 years ago.
Yeah, I think I'd reflect on my comments about the slowness of change and of pace, but acknowledgement, acceptance, and working towards change doesn't mean that there hasn't been some positives. I think the Aboriginal Justice Caucus, 23 years of engagement, and sometimes, I reflect on the fact that the agenda items haven't changed a lot over the years, but there have been successes that have been achieved before my time as Attorney General, and I've had the honour of finishing off, a bit too late, some of the things that they've been asking for some time. I see not myself as someone that should be congratulated for achieving something, but I've been the vessel of which Aboriginal Justice Caucus have achieved some outcomes. Coming back to my earlier point, the pace has been too slow. Is it held up for a variety of reasons? Yes, racism could be one. The practical restrictions on legislative reform, resource allocation, structural changes within governments and their agencies. These are difficult, complex issues, but I have optimism that we are acknowledging that racism is something we should address, and we're constantly learning how we can continue to do better in that space.
One of the ways in which the government is looking to work in that regard is picked up in paragraph 42 of your statement, I believe, where it's noted the government is committed to strengthening anti-vilification protections. Can you just speak to that for a moment?
Yeah, I can. So there was a parliamentary inquiry that looked at anti-vilification laws, hate speech, and basically the impacts of what's happening in Victoria in relation to how people are feeling, how they access assistance and help from the justice system if they suffer racism or indeed any form of inappropriate behaviour based on a characteristic. So what we did was advance one of the recommendations from that report in relation to banning of the Nazi hate symbol. That was picked out as something that was relatively straightforward in terms of legislative change. Anti-vilification laws, as reported to me by many stakeholders, both Aboriginal and other stakeholders, particularly called groups, and the LGBTI+Q groups, would suggest that the laws aren't robust enough, the thresholds are too high, some attributes are excluded, and it's not being used as an appropriate mechanism to respond to poor behaviour both civilly and criminally. In advancing anti-vilification reforms, we're embarking on a consultation process. I really hope that the consultation process brings about an educative function as well. These are the types of laws you don't really want anyone charged with. You prefer that people don't behave in a way that is racist, that is offensive, that is drawing on people's differences. Most Victorians want an inclusive society, but we need these laws to stamp out those very few that behave in inappropriate ways. So it's a commitment of mine to strengthen anti-vilification laws so that there's greater protection for people who receive harm based on a variety of attributes, including race.
And just in terms of the timeline or trajectory for that reform? Is that something you can talk to the Commission about, or is it a work in progress?
We're just at the early stages of consultation in relation to anti-vilification, so that is underway. There is a lot of interest in this space. I got asked in Parliament this week, how are you up to in terms of your timing? In terms of law reform, I've got a little bit on the agenda. I've got bail reform that we've announced. We've got raise the age that we are progressing. There's some other pieces of legislation and the like. As I said, in the development of anti-vilification legal response or law response, what that might look like in terms of legislation is one thing, but the consultation will be useful, and we're hoping to have legislation in the Parliament within 18 months.
On the same part of your statement, you talk about the government could do more to systematically monitor non-Aboriginal staff attitudes around racism and the criminal justice system and the exercise of discretion within the criminal justice system. While it's good to systematically monitor more, just systematically monitoring it is not going to change anything. Could you elaborate a little bit about what you'll actually do with that monitoring and how it will lead to change?
Yeah, no, I think I agree with you. Monitoring after the fact is probably not as useful as getting in there and demanding change on the spot. I think you can learn from reviews and examination, but I think ongoing cultural awareness and conversations in relation to how to make sure that racism isn't a feature of your organisation is something that's incumbent upon all organisations, particularly government departments. The evidence is clear why we should continue to have a real focus on ensuring that all people that work for the state and interact with Victorians are appropriately aware and treat people with respect and are culturally aware of difference.
If that's cultural awareness and more training, that presupposes that all you have to do is make people aware that they need to be not racist, and things will change. I suggest, especially with when you've got systemic racism in sentencing outcomes, police decision-making and cautioning and the granting of bail, that cultural awareness program is not going to cut it.
Yeah, I think that's a fair observation. In relation to my remit, I'm really interested in talking to the Judicial College and the providers of legal education and the like to understand how extensive their training modules are. I know that a lot isn't mandatory. I'm interested in learning more about some of the more successful programs and not. You're right, you can attend an hour session and tick a box to say you've undertaken cultural awareness training. That doesn't actually mean that your behaviour is going to change. I think there's a number of ways of changing culture. It's promoting good practices and having good mentors and having a diverse workforce. I would love to have more and more people of Aboriginal background working in the justice system, because I think that lifts everybody's ability to be aware of the factors that they should be in relation to interactions with Aboriginal people in the justice system.
And I suggest just finally that perhaps accountability for the leaders in these areas to make sure that we don't see these ongoing patterns of systemic racism in sentencing outcomes, police decision-making, cautioning, the granting of bail, that if that does not change, that those leaders are held accountable for that lack of change.
Yeah, I think held accountable for action, definitely. Ensuring that we should be celebrating the positives and promoting good practices, but we should also shine a light on poor practices so that people know that that is certainly not appropriate or accepted in an organisation, and that's certainly the job of a leader.
You mentioned a couple of times causal factors could be racism, but at the outset of your statement today, you acknowledged that there's systematic racism. So I just wanted to make a comment that, this is the foundation that we're talking upon, a lot of this important area today is around systematic racism. It's not could be, it is. I just wanted to make that statement.
Yeah, I think, and I appreciate your statement. I think absolutely I agree with you. There are other factors on top of racism, I think was the point I was trying to make, but I'd accept that.
Commissioners, I'm about to move on to another area, and if there are other questions on the issue of systemic racism.
I just wanted to go back, sorry, Mr McAvoy, because I just, you were talking about 6 years you've been talking to, and excuse me, I'll just try and find, I think it was under 57 of your statement. Whilst it says, whilst has pursued self-determination as a principle for 6 years, that's a long time to pursue self-determination. The government continues to develop and hone in to practical apply self-determination, achieving meaningful results. 6 years is a long time. What's happened? What have we achieved in the 6 years while we're waiting for the self-determination?
Well, the commitment to self-determination in six years ago is something that I think is fantastic, that it should have been earlier, that government agreed with Aboriginal stakeholders to principles of self-determination. Aboriginal stakeholders are continuing to update and give us examples and advice on what self-determination looks like. So I don't necessarily think that there is an end point where we say, yep, tick, we've achieved self-determination. I think we will continue to evolve and be a feature of learning, better processes, and more importantly, better outcomes. I'm not sure when we get to say we've achieved self-determination.
I probably didn't phrase my question as what have we achieved in the 6 years towards self-determination? I agree with you, it's not a tick box and it'll continue to develop and change. But what, I guess, if we're talking about the Aboriginal Justice Agreement, within those 6 years, what has happened towards self-determination?
Yeah, look, if I could perhaps draw your attention to the Aboriginal Justice Agreement Phase 4, just in terms of, you'd appreciate that I've been the attorney for 2 years, so only 2 of the 6 that people have been talking about self-determination and advancing. But on page 12 of that document, it talks about self-determination in action. And I think for me, when we're talking about self-determination, and similar to Commissioner Lovett's questions, practical examples are a good indicator of some of the outcomes that can be achieved through self-determination. So we've got new positions that have been created within the justice portfolio, within justice agencies, whether it be police, sheriffs, or courts and corrections, and then programs that have come out of consultation with Aboriginal Justice Agreement that are purely designed to divert, intervene and respond to Aboriginal people and some of the underlying causes that may bring them into contact with the justice system. So that is in terms of self-determination in what Aboriginal people think will work for their people in their community, and there's some examples of that. And so those programs have been given priority because they've been identified through self-determination principles.
But you agree there's a lot more work to be done?
Oh, absolutely. I think coming back to, as I said, the consultation, meaningful partnership, and then decision-making, there's elements of self-determination that should be throughout all of that.
Can I just make one final thing? It's worrying me from your last comment, that we've acknowledged that there's systemic racism. It's all through, it's come from colonisation, that's acknowledged. Yet what's to be done about it seems to be about individual change. I would argue that you can't change a systemic racism, and you can't unless you actually make systemic change. So individuals making change is not going to lead to a change in the system, so the racism will persist. You can have racism without racists.
When we talk about racism against Aboriginal people, I think it's incumbent upon government leaders to think about how we can ensure that the aspirations of Aboriginal people are the same as broader community aspirations. We need to ensure that we're not just focusing on the deficits and the problems to fix through racism, through a lens of racism. We need to help the Aboriginal people be better. That is racism in a sense.
I concur.
So for me, flipping it and identifying the positives and embedding them as you're not doing it to counter racism, you're doing it because it's the right thing to do, in a sense has a positive impact on reducing racism.
But even so, I'll go back to my point. You actually need to have systemic change to address systemic racism.
Agree.
Can it be good to understand, you talked about investment, and a lot of the comments made were around investing in, justice, the department, courts, etc. It'd be good to understand the balance of investment to community, into how much government is investing internally in itself towards that objective of self-determination, better outcomes for our people in the justice system. Do you have any sort of comments? But I think it'd be good to understand, how much investment is going out and inwards.
Difficult for me to sort of talk about figures, but let me know if I'm going down the right way with this answer. The justice system is picking up disadvantage and issues at the pointy end, at the tail end, and that's expensive. There are many opportunities for government, in particular, to intervene in people's lives to address issues earlier. We know that most people in the justice system, particularly in custody, have underlying reasons they're there, whether it's trauma, disability, poverty. There's so many factors that should be supported before coming into contact with the justice system. So identifying opportunities for investment, whether it is in kinder. I think that our government's policy in relation to free kinder for 3-year-olds and 4-year-olds is going to be a fantastic intervention, a fantastic opportunity to identify families that need support, so that those young kids don't then come into contact with youth justice system, or you're actually helping prevent intervention from child protection and the like. So in terms of where your investment as a government goes, of course we have to respond to crime, to community safety, but you can actually avoid a lot of those costs if you are investing in support for families, for children, for young people and for first-time offenders.
Just our community has been here before us asking for investment in early intervention for many years. Now, you just talked about kinder, early kinder. Some of our families don't access that because of stolen generations. Sometimes that's where kids were first removed, in their families. So they don't want to access these places because they're not safe. We need that early investment in our Aboriginal orgs. They're already there. They're screaming out for money. They have wraparound services for our parents to be able to progress the children to school, through kinder. They meet all their milestones. They support the families. And I think the advocacy that, they do through the Aboriginal Justice Caucus and through our agencies and through our community, it just doesn't seem to be heard. We've heard time and time again, we've consulted, but the money just doesn't go there. And it's really getting frustrating. And as a mum myself, I've seen it all firsthand. And as an Aboriginal woman, supporting some of these families is really difficult, because if you invested in these early years, we'd have so much better outcomes for our people. We wouldn't be spending so much at the other end. In the child protection system, in the youth justice system, in the criminal, I just don't understand.
Attorney, on that point, the Commissioners have expressed some views about the expenditure of $1.1 billion on a new remand centre, Western Plains, and the fact that that was a response seemingly to the bail reforms in 2018. It's now not in use, and the difficulty for community organisations to even get small grants for the early intervention work, and the disparity between such a large spend and the very small amounts that community organisations need to deliver those very important front-end services, early services.
Thanks.
Is there any comment you can make, Attorney, in relation to that type of concern that the Commissioners have expressed?
Well, I agree with Commissioner's comments in relation to investment in early intervention is something that I know we've been talking about for a long time, and I remain of that view. I've remained of that view since my first day of entering into government, frankly. I'd love to spend less at my end. I'd love to be spending all of it at the front end, and I think that that's something that we have an obligation to work on. In relation to the allocation of resources, coming back to some of the earlier comments I made about responding to what Aboriginal people say is best for their communities, identifying the programs and supporting the programs in an enduring way. There's some fantastic work going on out there with Aboriginal-led organisations, and I thank them from their work. I take motivation from talking to them, hearing about their stories on the ground, and in terms of the balance of where government spends the money, there are competing interests, but an interest of mine, an interest of many people in government is addressing disadvantage, helping vulnerable people, and we're very committed to investments in those programs. You always want more money for those programs, but hopefully we can do what we can to continue to support them and tilt that balance. I don't want to build any more prisons. Of course I don't. I'd love to build more culturally safe kinders, family programs. Of course, that's a much better use of taxpayer funds than prison.
I think broadly my comments were, or my questions were about the investment in, we've seen a growth in, I guess, the public service around, when you are funding programs that staff internally have to, I guess, look over and monitor progress around how these ACOs and so forth are reporting. And it was probably just more around, again, there's a lot of investment internally, but not as much goes out to community as well.
Counsel, can I ask a question about systemic racism? As a former Supreme Court judge, I'm really appalled that systemic racism exists in the system, and I agree it does, and I have seen it. But the element of it that concerns me in relation to Aboriginal people is the undermining of their confidence in the system that it brings about. If people don't see the law as a source of protection for them, but rather a source of harm for them, then clearly the law is not operating equally. And I can't see how we can possibly expect a system based on respect, mutual respect for equal human dignity being the foundation of a treaty, unless the law is seen to operate equally as regards all partners. We have heard evidence of people expressing that want of confidence in the law. A really good example of how of the inimical consequences is the lack of any serious legal challenge about the exercise or misexercise of child protection decisions. There should have been in the Supreme Court many cases that have looked carefully at the exercise of those discretions from the point of view of the Charter, from the point of view of foundational public law principles. That hasn't happened. It has happened in relation to areas like mental health and some others, but not there. And one of the reasons I believe is that people haven't seen the law for them. They just see it operating in the way that they expect it to operate, which is unequally along racial lines. So before my next question, I wonder whether you'd reflect upon the need to attack systemic racism from the point of view of restoring confidence by Aboriginal people in the law itself.
Yes, thank you for your comments, Commissioner Bell. I think I agree with a lot of that, and there's a lot of different angles we could go down in the issues you've raised. I think it's incumbent upon courts to be more culturally safe, and I think that we have made advances in that in relation to Koori courts. They're a similar kind of feel to this commission in terms of being less intimidating for Aboriginal people, involving elders. If anybody has the opportunity to check out the Bendigo law courts, I'd certainly urge you to do that. That was certainly a project both through infrastructure and through programs, really wanted to be a place that could be positive for Aboriginal people, not just somewhere that you came to get told off and potentially given a criminal consequence. Building that confidence, breaking down that it's not just the law imposing outcomes on Aboriginal people, but working with Aboriginal people about how the law, how courts, how justice can be a positive intervention in people's lives. I think we've got good examples of that, but there's certainly more to do. I hear from stakeholders how intimidating it is to have a conversation with a police officer if you're Aboriginal because of generational trauma, and I understand that. Courts is similar. I've heard awful cases of people on the stand feeling uncomfortable and just pleading guilty even if they haven't been asked whether to plead guilty or not. Like, the system has not been accommodating for Aboriginal people, and we acknowledge that, and we need to ensure that it is a much more culturally safe place so that you can explore those positive interventions. As we were touching on before, often when an Aboriginal person has come into contact with the justice system, it's a feature of several failures of opportunities or missed opportunities to intervene at a more appropriate time. So ensuring that you have an appreciation of that, I think, is really important for the justice system to be more responsive to Aboriginal people.
Thank you. My second question goes to the topic of the need for there to be systemic or structural change as part of the response to systemic racism. The Charter was intended to be such a change. There is an equality right in the Charter. It's defined by reference to discrimination in the Equal Opportunity Act. That includes racism. To exercise a discretion by reference to a racist criteria is a plain-bred Charter breach. The Charter was introduced in 2006, as you well know, and yet there doesn't seem to be the kind of understanding of obligations under the Charter within Charter-bound agencies, as I would expect there to be this long after the event. Have you reflected upon whether the Charter is strong enough to make an effective contribution to preventing racism and to providing redress when it occurs?
I've reflected in the sense that you're not the first person to raise concerns of that nature with me. I think ensuring that there's greater awareness of the Charter, I think it's been around for 20 years and it's embedded in a lot of processes, but is it understood and well known? Probably not. Certainly conversations that I've had with the Commissioner at Yoorrook in terms of the role about ensuring that we can explain better the rights and responsibilities of people. I think it is well understood in government agencies, perhaps to the point where it's got it's not as front and centre as what it was, because it's become so a regular process, and perhaps maybe refocusing our attention on its purpose isn't a bad thing to consider.
Thank you.
Thank you, Commissioner Bell. I just want to take you now, Attorney, to an issue involving this particular commission before moving on to issues of substantial reform, standard reform. This commission is the first of its kind in Australia, and in this respect, the First Peoples Assembly of Victoria and the Victorian government are clearly showing great leadership, but the terms of reference for this commission are far-reaching, and the level of inquiry needed to be undertaken has and will continue, it seems, to clash with the need for cabinet confidentiality. You're aware, I'm assuming, that there has been some difficulties with the production of documents and the use of documents in this commission. Are you?
Yes.
I suggest to you that if the historic and continuing causes of injustice to First Peoples in Victoria is to be properly understood by the Commission and by the public, there's a need for a degree of transparency about this process, the evidence before it. You'd agree with that? I suggest to you that it appears that a specific model of document production and use will be needed to facilitate the fulfilment of the terms of reference of this commission going forward in future hearings. And I ask, is the search for an adapted or different model which can better suit the needs of this commission something that the government is willing to participate in?
Well, we have been participating in a process to be very transparent, to provide the documents necessary for the Commission to do its very important work. As Attorney General and as Chair of a Cabinet Committee that considers such matters such as public interest immunity and the like, I've had to bring some perspective to some decisions in relation to documents that bring me outside of a participant of Yoorrook to make sure that I can apply the principles of what are important to the fundamental foundations of government in protection of Cabinet in confidence, Cabinet discussions, but we have tempered that with what is required of the Commission, and we have made decisions that have gone further than what we have in the past in relation to ensuring that as much material as possible can be provided to the Commission. And to my knowledge, it's only the documents that go to effectively the conversations within the Cabinet room that have been withheld. And with respect to, I stand by that decision. Cabinet decision-making processes within the existing framework of government is a series of people bring a series of views, can have arguments, can have robust discussions, and then a position is formulated and everyone gets behind that decision, and that's communicated to the community, and we stand by that. And I think if you start to infiltrate that process too much, you risk that robust debate, you risk frank and fearless advice from departments because that's important to government decision making. So whilst we have been, in my mind, it's accommodating almost as possible, to the point of wanting to, of course we want to give the Commission everything, but there are some materials that have been withheld for that very reason, that very small cohort of documents in relation to the Cabinet room.
It is, in many cases, I might suggest, Attorney, the very documents of which you were last speaking that go to the heart of the decision-making processes and the heart of the structural issues that the Aboriginal people in Victoria face. Now, the Commission is very alive to the need for cabinet confidentiality.
Mm-hmm.
But if the Commission were to seek to find some further adapted mechanism to deal with those documents in a way that allowed them to be more transparent in their use, the question is that something that the government would continue to participate in that discussion?
I think the conversation has...
Would my learned friend please consider clarifying the reference to being more transparent in that question? There is, I fear, a risk here of confusion about two different concepts. One is disclosure of documents to Yoorrook, and I, on that point, add that with the exception of notes of discussions in Cabinet, there's been a great deal of transparency. However, many of the documents that go to Cabinet but fall short of disclosing actual discussions in Cabinet have been subjected to a form of claim under which the government asks Yoorrook not to disclose that material more generally to the public at large. So there's two tiers of transparency involved here, and I'd ask my learned friend, Mr McAvoy, to be clear about what issue he's directing his question to.
Could I just jump in and make a comment? I mean...
May I just respond so that we're clear? The transparency of which I speak is the obligation of this Commission to be able to be transparent to the community, and particularly the Aboriginal communities. It's not the question of whether the documents have been provided to Yoorrook, but rather what can be done with them and how it can be done in a way that satisfies the community that the truth is being pursued and that their matters aren't being dealt with secretly. Commissioner?
And just to complement that, I mean, you'd be well aware, and I know you've been tuning in, that we did have to call a directions hearing in April, about this fact. Not to the level of detail you're talking about, but broadly, we did have to ask for government to come to the table in good faith and be more transparent with the documents as well. I just wanted to put that on there.
Yes, thank you, Commissioner.
So, to be clear, it's not suggested that there hasn't been work to date. There has been work to date, but, Commissioners, the proposal being put to the Attorney is that there can be more work done to figure out a way in which this Commission might be able to be more open with the Aboriginal community who are demanding answers. Attorney, I'm not sure whether you answered that proposition when I put it to you earlier, but is it something that the government is prepared to do with Yoorrook?
I think that the conversations about documents have been ongoing, and it is always the intention for government to be as accommodating as possible. I think that, I don't know how many documents have been handed over. I know it's a lot. I haven't had the opportunity to review all of them personally, but we certainly want you to have what you need. So more than happy to continue those conversations.
Thank you.
Mr McAvoy, can I just say, we knew this was coming, and we know that there's a lot that we're going to ask for, and there's a lot. It's from 1788, our terms of reference to today. So I don't think anything's a surprise to anybody, And just that waiting or arguing about documents, our time's running out here to get this commission done. And I just agree with Mr McAvoy and Commissioner Lovett that we need to be timely in these responses because we're having money going into directions hearing or arguments about documents that actually could go towards going out and hearing the truths of our community. So I just want to put that on the table. Thank you.
Thank you, Commissioner. Now, Attorney, there are a number of matters within your portfolio which you've addressed in your witness statement. The first of which I propose to take you to is the issue of public intoxication or public drunkenness.
Mm-hmm.
You were sworn in as Attorney General on the 22nd of December 2020.
I was.
And so it's the case that the Summary Offences Decriminalisation of Public Drunkenness Bill had already been tabled in Parliament by the time you were sworn in as Attorney.
Yes.
But of course you picked that up as one of the important matters that you had responsibility for.
Correct, and took passage of it through the Legislative Council.
And that passed through the Legislative Council in February 2021.
Sounds right.
And you've had carriage of that matter since that time.
The legislation, yes.
On the 9th of April 2020, before you were sworn in, the coroner's report into the death of Auntie Tanya Day was released. Are you familiar with that date? Or will you accept it from me?
I do.
And that report, you'll agree, was highly critical of the failure of the Victorian government to repeal the public drunkenness laws.
Indeed.
However, in 2022, you had the responsibility for bringing before the Parliament the Crimes Amendment Bill, deferring the commencement of the Summary Offences Act 2021. That's correct?
Yes.
There was a great deal of discussion about the reasons for that deferral in the commencement of the repeal of the public drunkenness laws at the time, and the commencement of the repeal was deferred until November this year.
Correct.
I've got a Friday drunk in a public place, a front here in Gertrude Street, drunk in a public place before the coffee when met me, that cab driver smelled alcohol on me, and the first thing was, all right, I'm drunk, but it goes on, there's a whole lot of racism there that ended up with me being charged with all these charges because of drunk. Ringed up the police, he said, he smelled of alcohol, so I was a drunk. And I had 4 beers all day from 11 o'clock, and they nearly killed me because I had the thing we got pneumonia and I got asthma and emphysema, and it's racist fire here, copper. Get off the road, I'm waiting for cab. And then they try to handcuff me. They go, I'm up against the car now, the cops right over here. They give me down and down on my stomach. I couldn't breathe, I'm yelling out, I can't breathe. So I got some young fella in the pub across the corner, they come and they got some film clip of it, you know. So, and I'm charged with, I've got to front all these charges, and in the land of the lie, thief and murder, where they go, no treaty, no consent, no jurisdiction, and it's been jail for vagrancy in your own country.
All right. Thanks, Unc.
Yeah, that's not a bit. I'm counting on the time around there. Spirit in the north and I Choco Rivers. Yeah.
Thanks, Unc.
Thank you, Uncle.
Thanks, Unc. Thanks very much.
Thanks for coming.
You to ask these questions about this particular important subject, all right? Thanks, Unc.
Now, Attorney, the Minister for Mental Health and the Minister for Health also have responsibility in respect of the public drunkenness reforms?
Implementation, yes.
The implementation. I might just ask you to go to paragraphs of your witness statement. Paragraph 150 and 151. And if you could just, sorry, 149 and 150, I'm sorry, and just read those paragraphs for the Commissioners.
To deliver the government commitment of reducing the overrepresentation of Aboriginal people in the justice system and supporting a true transition away from a police response to public intoxication, the government will not legislate replacement powers for Victoria Police to respond to individuals who are intoxicated. Victoria will not have a protective custody regime, and a person will not be placed in a police cell solely on the basis of being intoxicated in public. I'm proud of the fact that Victoria is the first jurisdiction in the country to decriminalise public drunkenness without implementing replacement powers for police, delivering a genuine shift away from the archaic laws that have so disproportionately impacted Aboriginal communities. This decision was based on extensive consultation with Aboriginal community members, particularly the Day family, VALS and the AJC, and research into the experience of other jurisdictions which collectively demonstrated the risks of continued coercive police approaches to public intoxication in a decriminalised environment.
Thank you. Just to be clear, while the public intoxication laws have had a disproportionate effect on First Peoples in Victoria, the policy underpinning the reform is broader in that it's simply inappropriate to arrest and deny any person their liberty solely because they are intoxicated. Is that correct?
Can you repeat that?
So, while Aboriginal people are disproportionately affected, the underlying principle which supports the reform is that it's simply inappropriate to arrest and deny people their liberty simply because they're intoxicated.
The underlying reason for this policy position was to avoid Aboriginal people dying in cells. That's what drove the reform. Being put in a cell for merely being intoxicated was something that we saw as a contributing, or could contribute to deaths in custody. That was the motivating policy driver for this reform. It is a direct response to Aboriginal stakeholder advocacy, in my view. I acknowledge that other people will benefit from the reform, but the policy driver was Aboriginal deaths in custody for me.
And you acknowledge that the public intoxication laws are generally applied by police, exercising their discretion as to whether somebody appears to be intoxicated or not.
Yes.
And it's public knowledge, of course, that in exercising that discretion, they obviously turn a blind eye to intoxication by the mainstream community at sporting events such as the Melbourne Cup.
Yeah, I think that's right. I don't think you'll see many non-Aboriginal women who have been left by their friends on the side of the road drunk being picked up and put in a police cell. You don't see that. What we do know...
The police, they're a service, they're not a force, they're not the thing. They are, if you're having trouble getting home, they are supposed to get you home somehow, get you home safely, right? I asked one cop in the city there, sorry, we've got a job to go to, but instead of them coming up and treating me the way they did, they should have come and talked to me. And if there's any problem, it is their job to get me home safely. They're a service, not a force. And, but they all seem to be framework into, attack.
Lata. Not to take away from what you're saying here, I think we'll give the opportunity for the attorney to answer the questions about this particular point. Maybe not your case directly, but just more broadly about the system issues around this particular topic. Yeah, it's really important.
Very important.
Totally, yeah. And we want to give the attorney an opportunity to answer the questions about this. All right. Thanks, Hunt. All right, Mr. McAvoy.
Thank you. As you've referred to in your statement, Attorney, the issue of the particular impact on Aboriginal people of the public drunkenness laws has been known since the Law Reform Commission report in 1989 and the Royal Commission Aboriginal Deaths in Custody report in 1991.
Yes, I reflected on these matters in the debate in the chamber, that it was long sought after and overdue.
And as a result, over that period of 34 years, it's obvious that many Aboriginal people have been the subject of public drunkenness charges, notwithstanding the recommendations that those offences be reformed or repealed.
Disproportionate impact on Aboriginal people is undeniable.
Just at a broader level than just your the immediate response, are you in a position to offer the Commissioners any view as to why it has taken 34 years for this reform to come about?
Well, it's difficult for me to provide excuses on it, or even reasons. Other states have tried. Well, they've effectively decriminalised, but have different ways of doing that, and the experience and advice from particularly people with lived experience is that it's not true decriminalisation in other states. I know it's been long on the agenda of many Aboriginal advocacy groups on AJA in terms of wanting to decriminalise public drunkenness for that underlying reason that specific harm can be caused to Aboriginal people in custody, and just being put in custody for being intoxicated is not appropriate. I cannot reflect on why it took so long, only that I wish it didn't take so long. And I think that the tragic passing of Tanya Day, and I've met with her family, was certainly the catalyst for change in Victoria. It should have happened before it, but it's now happening, and it'll be enacted in November this year. It was not, delaying it wasn't something that I was particularly proud of, but it was something that was necessary, and I spoke to the Day family about the reasons that was important. So it will be important that we stick to that date, and I have a firm commitment to you and to the Aboriginal community that have been long advocates of this reform, that it will be enacted by November this year.
Thank you, Attorney. In this reform process that's currently underway, one of the organisations which has been vocal in its opposition has been the Police Association of Victoria. You're aware of that? Yes. The Secretary of the Police Association of Victoria, Mr. Gatt, has previously expressed concerns that that the proposed reforms were dangerous virtue signalling. Have you heard that expression used in relation to these reforms?
Similar language, yes.
He made complaints that the health response would cost millions of dollars, and I suggest to you that the comments attributed to Mr. Gatt were whilst, I'll put it in this context, whilst he has a role in terms of representing the members of the Police Association, they can only be understood as an attempt to undermine the government reform. Would you agree with that?
Look, I can't give you an answer as to the intention of Mr Gatt's language. That's a matter for him. Mr Gatt has been vocal in some of these issues and is entitled to his opinion.
But on its face, it didn't assist the reform process.
In my dealings with this reform, it wasn't comments that led to the delay, if that's what you're asking. The reform was settled and agreed in the Parliament in February 21, and it is in various stages of implementation through 4 trial sites. The delay is attributed predominantly to impacts on the health sector, understandably, who were focused on dealing with the pandemic. The 4 trial sites are in various stages of implementation with a view to implementing the full reform by the end of the year, November.
The term virtue signalling is one with which you're familiar.
Oh.
And I suggest to you that it has a understanding of implying that somebody lacks sincerity and is merely doing what they're doing for some effect without any real commitment to the issue. Surely that can't have been helpful to the reform process that you're trying to deliver.
It didn't distract me from my commitment to this reform. I think the most compelling audience, the most impactful people in relation to who this means something for was the Day family to me.
Did the attitude of the Police Association to this reform have any impact on the conduct of the test at the test sites?
I can't answer that.
I'm going to stay with the Police Association for a moment, but in the criticisms that were publicly made in relation to the public drunkenness reforms, there was a call for replacement powers to arrest and to transport, detain and move people on who were drunk. And one of the points that you, in your statement and in press, have made clear is that the Victorian government has not given the police what they are calling replacement powers. Can you just explain to the commissioners the reasoning behind that, the rejection of that call?
We wanted to bring about cultural change, legislative reform that was a true decriminalisation. We have heard from other states that have coercive or residual police powers remaining in a decriminalised environment for intoxication, that it really didn't bring about the cultural change and impact that they would have, that the intention of the decriminalisation had. So we've gone down the route of ensuring that we want a true health response to public intoxication. That's not to take away police's ability to deal with inappropriate behaviour, disorderly conduct, crime, aggression and the like. This is to ensure that if someone is merely drunk in public, that is not a factor to be put in a police cell to sober up. We want to have investment in health responses, or indeed, where appropriate, to somebody to just go home. Not arresting someone for just being drunk is something that we are committed to. We think that it'll bring about a greater, a better health outcome for Aboriginal people in particular, who we know have been disproportionately impacted in the past by being arrested for, as Uncle has drawn our attention to today, having a few beers.
Indeed, I suggest to Attorney that the reference to the ability to transport or detain or move people on as replacement powers is indicative of an understanding of the public drunkenness laws as being much broader than what they are and being perhaps used for collateral purposes.
Take that as a statement.
It also appears that it's been used on occasions as an alternative to the public nuisance laws, an entirely different offence. Do you want to comment on that?
I don't have... What will be interesting is to... what's important to me when these laws are enacted in November is to pay really close attention to it. We are aware that there could be unintended consequences, or we hope there's not the consequences of upcharging, for instance. I don't want to see people that would have ordinarily been charged with being intoxicated in public get a more serious charge to deal with that behaviour. We don't want to see that happen, and that's an ongoing conversation with the police and the agencies on the ground, and indeed people with lived experience. That's why, rather than have a review of this legislation in a year or two, which is often what happens, we've made the decision to have an implementation monitor, for example, so someone that can oversee the legislation, speak to the stakeholders, Aboriginal stakeholders. This will be through an Aboriginal lens, coming back to the intention, or the main policy driver for this is to avoid Aboriginal people in custody for merely being drunk. So having somebody that is overseeing this reform to report to government, department, be transparent about how it's working is going to be really important, because it is a difficult, complex area of public behaviour and responding to issues. And the police want to, their job is to protect people, and that includes people that are drunk. And there are going to be challenging issues where, what do you do when you come across someone that you're concerned about? And we want to make sure that there are alternatives for police to be able to refer to, and indeed opportunities for people to have avenues to get home, access health, have a friend. We think we can do better. It's not just a police response, it's not just a health response. I think there's a broader community response.
Tell me a little bit more about, I'm interested in your, that there's going to be oversight of this right from the start. Can you tell me a bit more about who's going to oversight, where it will be placed and how they'll report and monitor?
Yeah, we're just working that out now. We want... and I think implementation monitor sounds like the wrong word, and I'll get back to you if I've described the wrong word, but effectively a guardian of the legislation. We want somebody that in real time can report to government about how it's working, rather than me being presented with a series of stats a year or two after that demonstrate there's a problem. I don't want to be in that situation. We know that this is difficult. We know it's challenging for police, for health providers, and for the community. So we want to see how it's working so that we can tweak the system if we need to as it's rolled out.
You spoke about upcharging. Clearly, there's a challenge, and I understand from your discussion on that point that it's something that those in charge with the design of the system are fully aware, but clearly there's a challenge to ensure that that the path of least resistance for an officer is one that allows for a health response and it doesn't incentivise criminalising conduct in another way. You'd agree with that?
I agree with that, and in my discussions with police officers, they'd much prefer drunk people be dealt with by health providers and not them.
That may be so with some of the police officers you've spoken to, Attorney. Much of the evidence here is in this commission relates to the circumstances that our uncle in the audience has spoken about, where it's being used for perhaps other purposes.
If there's other options, hopefully that's much better.
Can I just ask, how do you, I think you said the word upcharging, How do you monitor that? That people aren't getting another charge?
That's what would be important to have a monitor, but we have the Crime Statistic Agency and the like who can help with the collection of data, and I can come back to the Commission when we're a bit more firmed up in exactly what that will look like. But I'm alive to the issue that could be a problem, and we want to make sure that it's not. So the way to do that is to keep a close eye on it.
Yeah, that would be great.
Oversight mechanism have, an Aboriginal lens or a stakeholder or someone involved in that?
That's the absolute intention, yeah.
There's been a couple of references, and I asked a question early on about what partnership meant to you, and you referred sometimes to the word Aboriginal stakeholders
Yes.
in your responses. And the Aboriginal stakeholders, in my view and my knowledge of our community here, are Justice Caucus members. So I just want to sort of understand, because partners have more weight in an authority, I would sort of feel, generally thinking around those words, partners. You listen to, you respond and engage. But yeah, I just want to clarify, what do you mean by Aboriginal stakeholders? Because,
I guess it's a good point. It's a collective term for the groups of people that I value in terms of who I work with. So Vals, Jira, Rajak chairs, caucus co-conveners would be people that I regularly speak to. I guess one of the best parts of my jobs, or one of the things I like enjoying, is not just speaking to the leaders of those organisations, but visiting those organisations and talking to the workers on the ground. Because I think one of the most valuable things for me, as the attorney, and as thinking about how laws and policies and how they are going to apply, listening to people that either have lived experience or working and supporting people with lived experience is actually really valuable. And so I wish I had more time to do that, because it is one of the best parts of the job, and you learn so much, and you can think about the practical application or the consequences for your decisions. So when I say, I don't mean to diminish the value of their contribution, but I guess it's a collective term of I really value people's feed in, and many of them are partners, and some of them, I guess, are just people that have got good stories to tell me.
Yeah, I think it's really important. I mean, because a lot of the time, our advocacy is kind of diminished by the word stakeholders in a sense. So I think it's important that we just, understand where you're coming from. Also as well, I mean, as you acknowledged in the outset though, that we do have inherent cultural rights to this country, which elevates us way beyond the terminology and weight of a stakeholder.
I'll take that on board. I like that. I'll think about that language.
And particularly in the context of our aspiration that we want to turn into an actualisation around treaty as well. We've got inherent cultural rights to this land. And I'm probably sound like I'm banging on, but we are the first law people of this land. And I just wanted to really make that point. Thank you.
Thank you for making that point. Appreciate it.
Thank you, Commissioner. Just following on from that point, on not the point on partnerships, but the point in relation to monitoring. Are you aware of any estimates or actual figures of any savings or additional costs that the police service might have from officers not being involved in attending to public drunkenness matters?
No.
Is it something that the government proposes to undertake?
We've got statistics on how many arrests have been made for public intoxication charges. I can certainly provide you with that. But it will be resource intensive and expensive for a health model as well. So I guess in relation to the motivation for this policy, this isn't an economic saving driver. This is a doing the right thing by people policy, I would suggest.
Not a suggestion that the savings that the police service may achieve is a driver, but it's simply to draw out any figures that may be available as to whether the police service is making savings from not having to engage in the detention of people for drunkenness.
I can take that on notice.
Thank you. Commissioners, It's 10 to 11. We've been going since 9 o'clock. It might be a suitable moment for a morning tea.
15 minutes.
Thank you.
So we'll adjourn until
11.
after 11.
Yeah.
11. After 11. There's 5 minutes to tidy up. Thank you.
Well, shall we resume at 11:05, Chair?
It's 11:05.
Thank you.
Yes.
Chair, Attorney, I just wanted to take you back to a topic that Commissioner Bell engaged with you on a little bit before the morning tea break, in relation to the Victorian Charter of Human Rights and Responsibilities. Are you aware that the definition of discrimination, racial discrimination as it appears in the Charter, relies upon the Equal Opportunity Act for the definition?
Correct, yep.
And you're aware of the situation with the definition of services as it currently operates within the Equal Opportunities Act, where there are questions about its applicability to police officers and custodial officers. Are you aware of that?
Yes, I am.
Is the reform of the Equal Opportunity Act to ensure that that gap in both that Act and the Charter are closed?
I'm aware of the problem, not necessarily landed the solution. I acknowledge that the Equal Opportunity Act has some limitations in how it's applied to provision of services and how that's defined. What I'm not yet satisfied of is that by changing the definition, we would be fully across the consequences. So I'm more interested in identifying the problem and solving the problem, and making sure that legislative change enacts that. I'm a little, just not having had detailed advice on this, I wouldn't be in a position to commit to a change of the definition without further consideration about the ramifications of that, but I acknowledge that there are limitations in the ability for people to make complaints under that system. I think the broader conversation about police oversights and the ability to make complaints and how they're dealt with is relevant to the applicability of the Equal Opportunity Act, and also we have our anti-vilification law reform that we discussed earlier today, which would also potentially be a vehicle to accommodate how those complaints are dealt with.
Thank you. I will draw it to your attention that the Victorian Equal Opportunity and Human Rights Commission has made a submission to this commission of inquiry, and it's recommended that the Act should be amended to include a provision that some of the other Australian jurisdictions have, which is an amendment to prohibit discrimination in the administration of government laws and programs. And so that's a matter that you as Attorney General can take into account, the recommendations of the Victorian Equal Opportunity Commission in formulating an appropriate response.
Yes, I commit to that.
And is it something that's going to be dealt with in this, or could be dealt with in this current round of reform?
Anti-vilification reforms, yes.
Thank you. Okay. I now wish to take you, Attorney General, to the issue of the raising the minimum age of criminal responsibility in Victoria. Do you have at your fingertips, Attorney, the numbers of children that are involved in the 10 to 12 age bracket and the 12 to 14 age bracket in terms of interaction with the criminal justice system?
In the 10 to 12 bracket, the most recent data for an annual set is around 150 children alleged to have committed a crime. That is almost half of what it was in 2017. The numbers are higher for the 12 and 13-year-olds, and I will get you that figure because it's not coming to me right now, but it's higher.
It is high, but the figures in all respects are relatively low in the scheme of things for both categories. Would you accept that?
Oh, absolutely, yep, and trending down.
And you agree that of both of those categories, the under 12 and the under 14, there's a disproportionate ratio of Indigenous children coming into contact with the criminal justice system.
Yes,
And that's concerning.
absolutely.
And you're also familiar with the research that suggests that once a child comes into contact with the criminal justice system, the likelihood of continued contact with the system is greatly increased.
Yes, I'm aware of that. Contact amounts to more likely future contact, and incarceration almost guarantees it.
And so it's not necessarily being charged and convicted, but simply being dealt with in the criminal justice system is enough to expose a child to that that risk of greater contact later in life.
It can be, although I would caveat that with programs or diversions or activities that are run by Justice to respond to young people can be positive.
Are you aware of data that supports the proposition that children, young or young people engaged in antisocial behaviour tend to grow out of that type of conduct as they mature?
Yeah, we call it ageing out.
Yes. You're also, I ask whether you are aware of that a high proportion of first-time interaction with the criminal justice system in the 10 to 14 age bracket of Indigenous kids are subject to child protection orders.
Correct.
And we know that in almost all circumstances, those children will be suffering some form of disadvantage and likely to have some untreated trauma in their history.
Yes.
The Standing Council of Attorneys General met on the 28th of April this year.
We did. It was last week, I think.
And you attended that meeting on behalf of the state of Victoria.
Did.
Each of the other states and Commonwealth were represented by their respective Attorneys General.
Yes.
And as a result of that meeting, a communique was issued.
Yes.
Prior to your attendance at that meeting, did you have some expectation that all jurisdictions would agree to raise the minimum age of criminal responsibility to at least 12 years of age?
At a prior meeting last year, all states and territories agreed to, and the exact wording will be in that communique, but agreed to advance changes in each of their jurisdictions to seek to raise the age of criminal responsibility to 12.
And in those discussions, including at the meeting on the 28th of April, was it discussed that a national increase to 12 years of age not be seen as a cap?
Oh, yeah. Yes, in terms of it, I don't think that's ever been anyone's understanding. So I don't recall it being actually discussed and...
Yeah, I object. If Melinda Friend could just be a little cautious about not attempting to elicit any confidential discussions of the Standing Counsel of Attorney General. And I'm not saying that he is intending to do that, but it might be misinterpreted by the Attorney General that the question is intended to elicit confidential discussions between the Attorney Generals. Thank you.
Thank you. It's your understanding, though, isn't it, that one of the factors of reaching a national position was that the Northern Territory had already committed to raise the age to 14 at some point in the future?
Northern Territory and ACT have been advanced in their policy development, correct? Victoria is the first state to formally commit to legislation to raise the age to 12 with a view to 14 in a stage 2 process, and both ACT and NT have taken similar approaches, and other states remain open to what they might do in their jurisdictions. You reflected on the national approach. It's fair to say that different states are moving at different rates, but it's an important national conversation to have. For me in particular, who's a local member for Northern Victoria, half of my electorate is abutted by the New South Wales boundary, and for communities such as Albury-Wodonga, it's always great if you can have uniformity in your laws. So this one in particular is a good one to keep on the national agenda, and it's, you know, we're talking about young people, and not just the age that's important, but sharing what other jurisdictions are doing to ensure that young people don't come into contact with the justice system is also SCAG's a valuable forum for those discussions.
Thank you. And so, prior to the Standing Council of Attorneys General, and I may be incorrect on the date, but it appears to have been the 25th of April 2023, on Anzac Day, there was recorded in the Age newspaper that the Victorian Government approved a raise in the minimum age of criminal responsibility to 12 at a Cabinet meeting on the 24th of April 2023. Correct? Are you aware of the newspaper article?
I'm aware of the newspaper article.
Yeah, can you confirm that the newspaper article was correct in reporting that there was a Cabinet meeting on the 24th of April 2023 which approved the raising of the age in Victoria to 12?
I came out on the 24th and confirmed that formally, yes.
And it wasn't just limited to an approval of the raising of the age to 12. There are other aspects to that decision. Are you at liberty to speak to the Commissioners about what the other aspects of that decision are?
Yeah, sure. So what we have announced that we are doing is legislating for raising the age of criminal responsibility from 10 to 12. It's our intention to bring legislation to the Parliament this year. I think it's scheduled for around October, with a view to that becoming enacted in the middle of next year. In addition to that, we want to have a look at how we can improve the common law principle of doli incapax, which is effectively the recognition that a child under 14 cannot form the necessary criminal intent for purposes of understanding that what they did is wrong. The reports is that principle is not universally applied across courts, particularly across the whole of Victoria. It is something that we're seeking to codify. I'm particularly interested in whether we can bring it forward more earlier to the process rather than in the court process, so that it's more of a factor in terms of charging, or more importantly, not to charge earlier on in the process. So that's part of the reform. We've also given a commitment to develop an alternative services model, which we will be able to, in effect, test with the 10 and 11-year-olds with a view to expanding it to accommodate a raise to age to 14 by 2027, and ensuring that we've got all of the systems in place to, a bit like we were talking earlier in terms of appropriate ways to intervene. So whether it's through an education lens or family support lens or child welfare lens, making sure that there are other options for children who may engage in concerning behaviour.
Thank you. Are there any questions on that?
Yeah, I just... so given the government's commitment to raise the age of responsibility to 12, delaying raising the age to 14, so this is really contrary to the advice of Aboriginal organisations, legal and medical professionals in child development, and given we're overrepresented in the out-of-home care system, it's Aboriginal children that are more likely to be affected, I guess, by this. What is the... You've said the services, but we've also been told that it's a small number. So I'm trying to understand why the delay in knowing these children. We know these children, and why they have to come into the justice system, but we have to wait till 2027 for that small amount. I mean,
If I could offer some comfort in, I think, our thinking to this. There are a very small number of children that are incarcerated in custody that are under 14. Last week the number was 2, and neither child was Aboriginal. Where I'm interested in is the cohort of children that are not incarcerated but coming into contact with the justice system and ensuring that we've got more appropriate programs to deal with them. Undeniably, children have underlying reasons that they're being picked up by police and entering the justice system. A lot of them are in out-of-home care. A lot of them are, have underlying disabilities that haven't been picked up earlier, generational disadvantage, trauma, newly arrived migrants. There are so many factors that we should be dealing with more appropriately. Raising the age to 14 doesn't... We don't have to wait until raise the age to 14 to have those services available to those children. It is hopefully, it's my hope that when we do make the legislative change to 14, it doesn't have any practical effect, because all of the children that have been picked up by the justice system are already being diverted and supported in a more appropriate way. But we want to make sure that when we do raise the age, that safety net's there. I acknowledge that having a justice safety net right now is not ideal, but it is better than nothing, because the last thing I want to do is change the legislation to 14 and have children not having the option of a justice response and not having anything else, because I think you're just going to delay the consequences to later. And we know that if you don't deal with issues, it's not going to prevent a cycle of crime.
do you agree it's more like a health response, given the intergenerational trauma you're talking about, what children have gone through? Their mental health and their physical well-being is more of a health response?
I'd probably use the word well-being response. Absolutely. I've heard from not just Aboriginal partners and advocates, but also members of other communities like South Sudanese communities about some of the supports they want to help their young people. And they're similar but different, but at the underlying theme of all of it is a child's well-being and what they need to prosper, whether it's family support, assistance to remain in school, mental health treatment, substance abuse treatment. Unfortunately, there are a range of issues that, yes, health and wellbeing would be a much better approach than a justice intervention. But at the moment, having a positive intervention through any lens is better than none.
Can I ask then, why have we built another facility with 300 beds at Cherry Creek, I think it is? Yeah, that's sort of contradictory to what you're saying.
Look, in terms of the configuration of the custodial environment, I hope that we create the best environment possible for the last resort, when children may have to go into custody to deal with those behaviours, and this is something you might want to explore with Minister Erdogan. As I would repeat, I don't want it to be a government that's building prisons. I want to be investing in ensuring that young people in particular are diverted away from crime, so they're not in youth detention and certainly not ending up in adult detention later on. We need to really focus our attention on that, and I think raising the age is a way of doing that, because we are committing ourselves to a health and wellbeing response, not a justice response for that cohort, and that's going to make a big difference to the need, or hopefully the reduction of the need of prison beds in the future.
Can you explain to us you engage with Aboriginal stakeholders and partners, and thanks for picking up on the partners comment. Can you share some of the advice around their advocacy, particularly around raise the age? Or as in, what were their expectations?
Oh, look, I know that we've fallen short of expectations to introduce a staged response. I don't want to put words into advocates' mouths, but there's a recognition that taking a step is better than not. And they want to work with us in what the programs look like. Coming back to self-determination, I don't want to dictate to the Aboriginal community what we do with a 13-year-old Aboriginal kid. You guys tell me. Same with the South Sudanese community. Same with the health and education experts. They're the people that will draw on about what's the best approach to support those young people. So they'll be partners in this process. I know many advocates wanted 14 straight away. I would have loved to have done 14 straight away, don't get me wrong, absolutely. But I am scared that if we did that, we would have young people falling through the gaps, and that's unsatisfactory. NT, ACT have faced the same reality. Let's get it right in the small group first before advancing to 14. Unfortunately, there is more complex needs in the higher age group, particularly 13.
They were advocating for 14 though, right?
Always.
Yeah, and they've had to accept the position of 12 at the moment.
That is a fair assessment.
Talking about self-determination, what self-determination principles were involved in the decision around that?
That Aboriginal people know better how to help their young people than the justice system.
As in the decision to make it 12 instead of 14, given the advocacy of Aboriginal communities?
Of course I was aware of the advocacy being 14. We had to weigh up, we had to balance competing interests, competing views, what was ready to go in the system. You've heard from Child Protection. They're stretched. You know, they've got important work to do. If just raising the age would make a lot of that work more difficult and would have a downstream impact potentially on vulnerable children. So the whole system had to be considered in relation to the impact of those decisions.
Yeah, I understand that, but I guess self-determining principles weren't applied in that decision. That's probably what I'm saying.
Considerations, definitely. Decisions, correct.
Thanks.
Yes, could I ask, what is it that you have the capacity to do with respect to the sub-12 cohort that you don't have the capacity to do with respect to the sub-14 cohort that has enabled you to proceed now with respect to the former but not the latter?
Well, I think coming back to, it doesn't mean that you can't have services for the under 14 cohort as well. It'll just be that no child under 12 can be criminally responsible. So they won't necessarily, and we have to work through this.
But you've moved, and so I'm interested to know what is it that has enabled you to move with respect to the sub-12, and what is it that that in your judgment has not enabled you to move with respect to the sub-14?
We need to build the response. We need to ensure that the systems, the programs, and importantly the workforce is available. So by going to 12, as we indicated, around 150 little kids have been alleged to have committed a crime. That's a number that I know they're in contact with the justice system. It's less that are charged. None have been incarcerated. But it gives us an opportunity to start to get some good outcomes for those people, build and test our response. That doesn't mean that 13, 14-year-olds can't sort of access, and there's already diversion programs in existence. We're building it from, we're not building it from the ground up, we're building it from a couple of steps up. But we want to get it right, so we want to be able to do it incrementally. And if we can do it before 27, we'd love to, but we want to make sure that the services are available so that we get good outcomes and we don't just delay poor outcomes.
Is it the case then, given that answer, that the services that will be available to the sub-14 group will essentially be the same as the services available to the sub-12s?
Not necessarily. The older cohort have more, the evidence is more serious offending, still a small number, often more complex needs, often more difficult to have success in diversion. So we just want to stage it out and get it right. And hopefully, as I said, when we raise to 14, it's just catching up with reality.
Commissioner Lovett drew your attention to the advocacy from the Aboriginal groups involved in the sector, all strongly in favour of a raise immediately to 14. You're also aware that the medical evidence as to the state of the young people's neurocognitive development in children under 14 is clear.
Mm-hmm.
And I draw your attention to statements by the President of the Royal Australian College of Physicians that were recorded in The Age on the 25th of April, that raising the age of criminal responsibility to 14 years is critical to protecting the health and well-being of children and young people at risk of incarceration, especially Aboriginal and Torres Strait Islander children and children with developmental disabilities. So it's not just the Aboriginal community and human rights groups who are all advocating for the raise to 14, but the Royal Australian College of Physicians. So you accept that the medical evidence is strong on this point?
Yeah, I'll draw you back to the statement you made in relation to critical to their well-being, that they're not come into contact with the justice system, but I would also argue that it's critical to their well-being that there is an appropriate response. So I certainly accept that international evidence is that you should have a high, the criminal age of responsibility should be at least 14. That's universally accepted, but that's not the end of the argument for me. Sure, you can raise the age but if you don't deal with the issues, the underlying problems, why a young person is engaging in problematic behaviour, that's not fixing the problem as far as I see it.
And do you say that young people who are coming into the system are having their underlying issues dealt with presently? Sometimes,
yes.
It's not the case that the services are readily available to all young people, is it? That come into the system.
It's not universal and as robust as it should be, which is why our commitment to raise the age to 14 is also a commitment to build an alternative services model so that young people that are currently accessing the justice system for support services won't need to, because there'll be alternatives. I hope that there's a menu of options based on self-determination principles, based on best evidence about the different supports that different young people need.
Your evidence today indicates that you're really very well versed in the issues surrounding this matter.
Been a pretty popular topic since I've been attorney. Yep.
And you would be aware that there is research data to the effect that the coming into contact with the justice system through attendance at court is something that can affect a child's trajectory. You accept that?
Yes.
Where you've got children who are not necessarily guaranteed the service provision that they need, and they're nevertheless going to be dragged into the criminal justice system, would it not be better just to keep them out of the justice system?
That's the intention of the development of this policy, but I want a safety net for kids. I think that's important.
I think, to be more direct, I think the point that I'm making is that for some kids, the safety net doesn't exist in the justice system. Do you accept that?
Yes.
So there is this a gap there that the failure to raise immediately to 14 doesn't quite capture. Do you accept that?
I think it's more complex than that. I don't think any one child is the same. I've always maintained that there is an obligation on the criminal justice system to, when everything else has failed, for it to be a positive intervention in the life of someone who comes into contact with the justice system, because there is very few people that aren't there. You can't point to a reason that they've found themselves committing crime. We have a range of support programs, a range of diversion programs. Are there some people falling through the gaps? I'm sure there is. If you were to raise the age, I think you'd have, without filling the gaps with the proper support systems, you'd have more people falling through the gaps.
Could I ask if those gaps did not presently exist and you had the support systems you've described in place, including diversion and other programs, would you move to 14?
Yes.
Can I ask, in relation to the way the criminal justice system is organised, the principles on which it's based, individual responsibility for crime is the fundamental principle?
Sorry, can you...
Sure, I'll be more specific. We have a criminal justice system that involves individuals being responsible for crimes that they commit through the legal process, and that responsibility is founded upon notions of intention and individual consciousness of wrongdoing.
Yes.
The international evidence suggests that young people under the age of 14 are not sufficiently well developed to have that sense of wrongdoing and to form that intention.
Yep, similar to the conversation we had about
We had earlier.
dolly incubats. Yep.
Yes. Your approach involves, incidentally, I want to concede the serious significance of your commitment to rolling out programs that are diversionary, protective, and that attack the problem at a much earlier end. I absolutely accept that. But would you accept that your approach involves we as a community tolerating subjecting 12 to 14-year-olds to legal processes on the basis of notions of consciousness and intention and responsibility that they are not developmentally able to have?
Well, I think there's an acceptance in that of our commitment to raise the age.
Yes, but in the meantime, real young people aged 12 to 14 will be subjected to charging, will be subjected to trials in respect of crimes of which intention is an element. And yet the evidence shows that they are not developmentally mature enough to form that intention.
Yeah, no, I agree with that. And very few children under 14 progress to the full extent of the justice system. There are many opportunities to positively intervene, which is coming back again to if you can't demonstrate mental capacity for the purposes of criminal intent early, then of course those kids should be diverted out.
And your interest in dolly incubats.
Correct. I'm also really interested in restorative justice practices because at the end of the day there are also victims that are, regardless of the age of an offender, whose views are relevant here. And I think that there's quite a lot of evidence out there and examples of restorative justice practices, particularly Aboriginal-led restorative justice practices, where having a conversation that involves an offender, the family, elders is therapeutic, and if it's culturally safe, that's a great intervention, and it's through a justice lens.
Well, Attorney, I do accept that. Indeed, I applaud it. There was once an age when none of this was available. But I think you are asking us as a community to accept that young people who shouldn't be and couldn't be tried on the basis of individual intention will continue to be tried because 14 has not been. You have not moved to 14. I'm very uncomfortable about that because I have tried a person aged under 14 and it's left me. I won't say anymore.
No, I appreciate your. Thank you.
Just on Commissioner Bell's point, these are children, and that's in the context of talking policy or very few children. It is still a child that is still going to be impacted by this. And I personally know, of working in the child protection system for so long, on the opposite side, I've seen, and I've even seen some end up in adult prison and be a death in custody because of that trajectory. The kids in out-of-home care, when we're talking about, the crossover kids, they're not getting those early intervention services there around their well-being that is really required, and they end up in these systems. And one child is one child too many.
Thank you, Commissioner. Attorney, you're aware that there are many countries around the world in which the minimum age of criminal responsibility has been raised to 14.
Yes, I've been provided a list several times.
And you're aware that in different places, different models are used in terms of alternative service models? Yes?
Yes.
And are you aware that in some circumstances they use an educational model?
Yes.
And in others, a health model? It sounds from the evidence that was given by the departmental officers earlier this week that decisions have been made about the model that will be used in Victoria. Is that the case?
It's well developed, but not finalised, yes.
And that's I tried to characterise it in their evidence as a child welfare-based model.
Yeah.
I think they agreed, but I'm not sure that they agreed wholeheartedly with my characterisation of it in that manner. But that's basically the model. It will be dealt with through the Department of Family Fairness and Housing.
That isn't fully settled. I guess this will probably explain it best. The alternative service model is being developed through Department of Justice in collaboration with DFFH. So relevant ministers include myself, the Minister for Police, the Minister for Youth Justice, the Minister for Child Protection, and the Minister for Aboriginal Affairs. We were the sort of group that came together about what do we do to have a non-justice response. But in my mind, coming back to the way I describe it, a bit more like a menu, there's some really good justice programs out there. And I'm not convinced that just because you're not criminally responsible that you mightn't benefit from accessing those. We have to think carefully about that. But who provides the support and programs, to me, is less important than the outcomes that they achieve.
Certainly. But I'd suggest to you that in other jurisdictions around the world, the objective with respect to children who come into who are referred from the criminal justice system for antisocial behaviour of some type, the objective is to make them a better person, to help them become a better person than what they were before they got involved with the system.
Mm-hmm.
Is that really possible, applying a justice lens?
Well,
Because you're starting from the deficit position of being in the justice model.
Not necessarily, because we're talking about government agencies within the Department of Justice who can have a wellbeing focus as well to prevent crime, to prevent. So yes, I acknowledge that it's the child welfare and child protection have got good programs, and I think we should. I don't think we should silo it. Is probably my best answer. I think coming back to there should be a range of programs available for children to divert them away. And I'm not really too fussed if it's delivered by justice or not, as long as the underlying principle and what you're trying to achieve is picked up. I don't think it's necessarily a criminal justice lens. I think there's a difference between justice and criminal justice.
Thank you. Accepting that you individually have a strong desire to see the removal of children under the age of 14 from the criminal justice system. Accepting that for a moment. Would you agree that having the medical science information that we now have and has been available to all of us over the last 10 or dozen years about child brain development, neurocognitive development, that none of us in the system can say that we don't know that the children under the age of 14 in particular are not sufficiently developed to understand the consequences of their actions and the risks of their actions. Do you accept that?
Yes.
We can't say that we don't know. We know that.
Correct.
Is there some risk of liability to the government from not acting
We are acting.
with respect to the under the 12 to 14 cohort, given that the government has that knowledge?
I think it comes back to my earlier response in you need to ensure that you have appropriate support for these young people and not nothing.
Attorney, is the legislative proposal that you will be taking forward this year going to include a provision enacting the raising of the minimum age of criminal responsibility to 14, subject to some later commencement date?
I can't confirm the specifics of the legislation yet. We're not at that stage. Where we're at is what we've announced and our commitment to raise the age to 14 by 2027, subject to a consideration of relevant offences and the alternative services model. I think that public commitment is firm.
I'll ask you this. Do you accept that including that commencement date of 2027, as the government has done with the delayed commencement of the public intoxication reforms, would be something that would give the Aboriginal community and the Aboriginal Justice Caucus and this commission some greater comfort as to the actual implementation of that stated policy?
I think the government's public commitment is strong. I've made it on several occasions. The Premier has made that on occasions. When you put dates in legislation, look what happened with public drunkenness. I don't want to have to go back to Parliament and have a debate about this policy. I just want to get on with it. if we can do it earlier than 27, I'd like to do that. That's going to be difficult because we want to make sure that we've got everything in place. Whether you have a legislative trigger or a public commitment, I think that my personal commitment to particularly the Aboriginal advocates is we're getting on with this to get it done by 27.
And as I put to you earlier, your personal commitment's not in doubt, Attorney, but ministerial positions change, and there is an election in 2026 in Victoria. And this a position that's been arrived at where the government has only been able to move forward on the raising the minimum age of criminal responsibility to 12, notwithstanding the medical evidence and notwithstanding the strong advocacy from the community, I suggest to you would benefit from the greater security of being confirmed in legislation. And you're nodding, you accept that would provide greater security?
Depending on your perspective, I guess, but I accept your statement.
Well, and in the context where ministers do change.
Well, what I would say is that legislation does as well.
But you would agree that it's harder to change legislation than it is to change a policy position.
Depends on who's sitting in the chambers, but yes.
Attorney, I now wish to take you to the topic of bail reform. On Monday this week, the 1st of May, the Victorian Government published its response to the report of Coroner McGregor into the death of Veronica Nelson. Yes. I had intended to attempt to summarise the response, but I propose to ask you to go to page 36 of your written statement, and at the bottom of that page 36, you'll see paragraph 198 appears under the heading Future Reform. You see that?
Page
36, 30, might be 35. Paragraph 198.
Sure. Yep. Got
See
it.
the heading Future Reform?
Yes.
And if you can commence at that paragraph and continue over to the following page, and it's your statement, and you know that this section of your statement sets out your view and the government's view about the possibilities for future reform and some of what's intended. Is that correct?
Yes, particularly around bail, which, following the passage of time since I submitted my statement, we've been out in consultation, which is enabling me to speak a little more freely and less confined by my cabinet processes.
Yes, and I'm giving you the opportunity through your statement to speak a bit more freely about the options for reform and the directions that the government might take. So if you could start at paragraph 198, please, and just read.
Oh, sure. Sorry. Till when?
To the bottom of, well, if we can just start by going to the end of paragraph 200, and we'll just stop there for a moment.
I will soon introduce legislation into Parliament to amend the Bail Act to address the adverse impacts that have been well documented through this statement, earlier evidence, and of course in the broader community conversation. The reforms will maintain proper consideration of community safety and decision-making by maintaining an appropriately tough approach to those accused of serious offending who pose an unacceptable risk to community safety. Importantly, reverse onus bail tests will be limited to only those charged with serious offences and those who pose a terrorism risk. There will also be refinements to the unacceptable risk test to strike the right balance between violent and non-violent crime. These are not reforms I'm prepared to defer further, but they are most certainly not the only reforms that respond to the overrepresentation of Aboriginal peoples in the justice system that I'm prepared to prioritise for consideration during the time I have the privilege of being the Attorney-General. I'm not in a position to provide specific detail about the proposal that is currently the subject of consultation before finalisation of this statement. I hope to have more to share with the Commission on these matters at a later time that will assist in your deliberations and report.
There's two questions I have in relation to those paragraphs. Firstly, when you say you will soon introduce legislation into Parliament, can you be any more specific as to how soon?
This year?
Thank you.
August at the latest is the plan.
Thank you. And when you say you hope to have more to share with the Commission on these matters at a later time that will assist in the deliberations of the Commission and the Commission's report, is that an intention to provide further material that might go to the coming report on the criminal justice priority topic, or is it something that may come later?
I was specifically referring to the fact that the legislation would be more developed, and I could probably share that with you as it's being progressed. So the next report of this Commission is due on the 30th of June. We're not talking about that report. We're talking about some later report from this Commission. I guess I acknowledge the interest in this area of justice for the Commission, and so it's an invitation or an offer to continue to keep you updated as this is progressing in real time.
Thank you. The reform that you speak of in paragraph 199, in general terms, regarding the reverse onus bail test will be limited to only those charged with serious offences and those who pose a terrorism risk. And there will also be refinements to the unacceptable risk test to strike the right balance between violent and non-violent crime. In reaching that position, the government has taken into account the coroner's report in respect of the death of Veronica Nelson.
Yes, at the outset, I might take the opportunity to express my extreme sorrow for the passing of Veronica Nelson, send my condolences continuing to her family, friends and community. Bail, the issue of the need to reform the Bail Act was certainly brought to my attention upon commencement of Attorney General, very stridently by Aboriginal Justice Caucus in particular, but other Aboriginal representatives and the broader justice community, I've got to say, VLA, CLCs. So work has been underway prior to the inquest, but the findings of the inquest have certainly informed and been taken up as we are working through that legislation and those reforms. And I would say that it's there will be a continuation after the bill as well.
Thank you. The proposals that the government has in terms of reform are not on all fours, if I can put it that way, with the coroner's recommendations?
We are certainly responding to the most urgent issues that the coroner has identified. There are, I think, 11 recommendations in relation to bail, and we're progressing, as I understand it, about 6 of those in some way, not necessarily the same way as was advised by the coroner, but certainly will acquit the intention of some of his suggestions.
And so you've answered the question I was about to ask in part. The reasoning behind the departure from the coroner's recommendations is, if you could explain that for the commissioners, please.
Just by virtue of saying we can achieve the same thing differently. Appreciate the work that the coroner did. Really important story to be told. The practical outcomes of such a harrowing report for me are specifically in relation to his bail recommendations. He drew on those recommendations from the evidence that was presented to him. I have the benefit of having a department of experts who have the ability to consult more broadly with the courts, for example, on the operation of such reforms. So similar, we're doing the same thing in a different way because we've had the benefit of being able to test it more than perhaps the coroner has. But his recommendations, the most urgent parts of his recommendations, I believe, are acquitted by where we're headed in our legislation.
So the proposed the amendments as they are consistent with the principles that the coroner was striking at?
That's probably a better way of saying it, yes.
Can I ask what consultation was undertaken in relation to the government's proposed reforms prior to the response to the coroner?
They've been operating concurrently. So we went out on the timeline. We went out before the response to the coroner on targeted consultation with stakeholders.
Can you caucus, Justice Caucus?
Justice Caucus, VALS.
Stakeholders.
Yeah, I can get you a list. If
Was
you're-
Aunty Donna included in those consultations? I know you spoke earlier about Aunty Tanya Day's family, but was Aunty Donna, in the context of these reforms, consulted with?
The Secretary of the Department has met personally with Aunty Donna in relation to the coroner's recommendations and what the government's plans of actions are in relation to bail, yes.
But not yourself as the attorney?
I haven't met Aunty Donna, no.
Okay, thanks.
Now, I might direct your attention to paragraph 201 of your statement, where you talk about the 1 March 2023 consultation paper. Is that the same consultation as you've been discussing with
There's
Commissioner
my
Lovett?
answer to Commissioner Lovett. Yes, 1st of March was when the consultation paper went to stakeholders, yes.
And in paragraph 202, it reads, your statement reads, the proposed amended legislation is intended to appropriately address the issues identified in the current bail laws, which are echoed in the Veronica Nelson inquest, and to give effect to these policy objectives. A, refining the bail test to focus on serious alleged offending and serious risk. B, reducing the over-representation of vulnerable groups in the justice system, including women, Aboriginal people and children. C, promoting alternatives to remand that deal with the root cause of offending behaviour. And D, balancing the reforms with the rights and protection of victims/survivors in the community. You then, at paragraph 203, go on to set out the first proposed amendment. Might I ask you just to read that out?
203?
Yes, please.
The first proposed amendment is a differentiated child bail test where the reverse onuses no longer apply to children with limited exceptions. The Bail Act would be amended to exclude children from the application of the show compelling reason test and exceptional circumstances test with 2 exceptions. The intended effect of this amendment would be to reduce the incidence of remand of children, including Aboriginal children. Bail decisions relating to children would be solely based on the unacceptable risk test in the vast majority of cases.
Thank you. Are you at liberty to expand on what the limited exceptions are?
Homicide and terrorism.
And then at 204, your statement makes the more catch-all observation that the overarching intention of applying a differentiated approach to bail for children is to reiterate that custody must be used as a last resort for children. But that's a current principle, isn't it? That custody be a last resort for children?
That's why we're reiterating it.
Is there going to be further opportunity for the community to participate in the development of these amendments?
Yes, but I want to say limited opportunity. And the reason I say that is because this is the number one pressing issue in my portfolio. It has been for some time. It is the number one request of the Aboriginal Justice Caucus and other legal stakeholders, particularly those that deal with vulnerable cohorts. So we know what the issues are. We have that confirmed by a coroner's report. I want to get on with it. This is legislation that I've just indicated to you that I want to get into Parliament in the next few months. So I want to get that done, and then a conversation about any further reforms would more than welcome. But my priority is to reduce the remand numbers and indeed have less people who shouldn't be in custody.
And is that approach one that the Aboriginal Justice Caucus is satisfied with?
I've communicated that to the last Aboriginal Justice Caucus, and I think it's there is my understanding is there's acceptance of of me getting on with the first stage, because they're the most urgent requirements in terms of protecting vulnerable people or having a better response to vulnerable people. It's fair to say that there's interest in ensuring that I don't put a full stop on this reform, and that's fine. But that doesn't mean we should hold up the process to accommodate everyone's wishes. Let's get what we're agreed on now done, and have another conversation after that's passed.
Attorney, could I ask you to explain the justification for the two exceptions, homicide and terrorism?
It's just that it's still the fundamental principle that custody should be as a last resort, but having an exception for the presumption against bail for those two offences we believe is in line with community expectations.
Yes.
It doesn't mean that bail can't be granted.
Can't be granted.
It's just a
Higher test.
correct.
Yes. Thank you. I understand.
Thank you. Now, 205, paragraph 205 of your statement, Attorney, it's noted that the proposed amendments also include the introduction of Aboriginal child-specific considerations. Can you just explain what those considerations are?
As my statement goes on to say, this is under development and in consultation with the Aboriginal Justice Caucus on the wording of those considerations. I'm very interested in their views on getting this right.
At 207, there's reference to proposed amendments also involving refining the acceptable risk test to focus on community safety. It's in the second sentence. It says, by the proposed amendment which takes into account recommendation 4.11 of the Veronica Nelson inquest, the unacceptable risk test in section 4, capital E1A, would be amended to provide that the risk that the accused will commit an offence while on bail can only be an unacceptable risk if that offence would endanger the safety or welfare of another person. Is that the extent of it, or does it go beyond that?
I don't think that's limiting, but that's to capture the main intention of why we would make an amendment to that provision. So the mere risk that someone will reoffend in itself is not enough to provide or grant bail. It must be that that risk goes on to be a community safety concern.
At paragraph... I thank my learned friend. In your answer, Attorney, I think that you might have said not enough to grant bail when you meant not enough to withhold bail.
Yes, thank you for that. Thank you, yes.
I was prepared to let it slide, but...
That's an important clarification. Thank you for picking that up.
Paragraph 208 of your statement, you refer to the consultation paper also sets out proposed amendment to Section 3A of the Bail Act. The operation of Section 3A and its application has been something about which this Commission has heard evidence from a number of witnesses. The paragraph 208 says that the proposal takes into account recommendation 4.10 of the Veronica Nelson inquest, that is to update the existing set of principles that bail decision makers must take into account when making a determination under the Act with respect to Aboriginal IDOL as part of meeting the identified policy objectives, including overrepresentation of Aboriginal people and children in custody. The commentary that this Commission has heard about Section 3A of the Bail Act goes not only to its application, but or misapplication, but a misunderstanding by bail decision makers and some judicial officers as to how to properly apply that provision. Is that something that's been brought to your attention?
Yes, it has.
Is there proposed to be some further education of bail decision makers and judicial officers in that respect?
There is.
And what type of assistance will they get in respect of Section 3A of the Bail Act?
I've got some information in relation to bail justices. So there's, I guess for context, there's recruitment of new bail justices at the moment. The department's actively seeking to improve the diversity of applicants, including working with Aboriginal Justice and Aboriginal Justice recruitment team within the department to promote this as a volunteer opportunity. Aboriginal community-controlled organisations have been proactively contacted to promote this opportunity amongst their local communities, and Aboriginal cultural awareness training will be provided to all new bail justices prior to their commencement of the role, and there'll be consequences for not attending training. 4 bail justice volunteers who have not yet completed their Aboriginal cultural awareness training were suspended last week for not having undertaken that training. So we're taking it pretty seriously.
Thank you. And there is some commentary in your statement from paragraph 214 about the cultural awareness training for bail decision makers through to paragraph 221. That's correct?
Yep.
And the decision to suspend bail decision makers as a result of not undertaking their training, is that something that has been made public before this?
I don't think so.
Can I just ask, is that the first time that's ever happened?
To my knowledge, yes.
Attorney, the the reform process that's being undertaken with respect to the Bail Act, of course, is generally welcome. Clearly, it's too late for many people, and clearly, the state knew that the consequence of the amendments would be an increased prison population when it undertook those amendments.
In 2018?
2018.
You'd appreciate that I wasn't in this position in 2018, but the material that I've reviewed would indicate that that's accurate, yes.
And we've heard evidence from departmental officers during the week that there's a division within Justice which has the responsibility for trying to predict numbers and growth and decrease in prison population to ensure that the resources are there and available at the appropriate time. You're aware of that facility?
That's information that's provided to most development of policy, yes.
And it was on the basis, it was my understanding of the evidence, on the basis of that information that the Western Plains Remand Centre was built.
Prison population numbers would be the driving reason for that facility, correct?
And before the amendments were brought in 2018, there was strong advocacy from the Aboriginal community through its representative organisations making clear that they understood that it would disproportionately affect Aboriginal people.
Yes.
And we now are in the situation in Victoria where the Aboriginal remand population in adult prisons is at an extraordinary rate. You accept that?
Unacceptable rate, yes.
Unacceptable?
Unacceptable.
Clearly nobody would wish an event such as happened on Burke Street and prompted these reforms to happen again, Attorney.
Mm-hmm.
But there seems to be an argument that the Aboriginal community in particular paid the price for that event. That the price was a strengthening of the bail laws in a way which particularly captured Aboriginal adults and children. There were other options open. The government could have, as it's done with the mental health system levy, raised funds from the various forms of industry around the state to do front-end work. And a decision was made to punish the poorest people in the community. Would you agree that assessment of what occurred is open on the known facts?
As you've indicated, it was a challenging time responding to such a horrific incident, and community expected government to act with force, in a way that promoted community safety. I share your view that no one wants to see something like that happen again. The laws, the government at the time sought advice on how we could best respond to that. Options were presented. I wasn't a part of the decision-making there, but as a member of the government, it's incredibly challenging balancing up a range of interests. In relation to this particular reform, what we know now is that the balance was probably wrong. I know it was wrong, and I'm seeking to recalibrate that balance or tip it back so that we are appropriately dealing with serious offenders. Appropriately, those people should be remanded. But the evidence is clear. We've cast the net quite wide, too wide, in the bail changes, and we've picked up vulnerable cohorts, including Aboriginal people. That's why it's my number one priority since being re-elected to get on with it and fix this.
Accepting absolutely that it's your priority and that you weren't involved in that decision. The decision, though, in 2018, with the knowledge that the government had from the Aboriginal Justice Caucus and other advocacy bodies, to borrow the vernacular from the racial discrimination field, was an act of punching down on the Aboriginal community and the disadvantaged communities in Victoria, I suggest to you.
It's difficult to put myself in the position of the decision makers at that time, but it was an incredibly emotional time, and there was a lot of factors that would have been in the minds of people making those decisions. Responding appropriately to such an event, to responding to community fear, was something that governments are responsible to do. What you've picked up on is consequences of those decisions, known or unknown, should be better factored in when we're making those decisions. And I think that the experience of our bail laws has been a sober reminder that you need to be really careful about making changes to laws and the impact that it has on vulnerable people.
Although it wasn't intended that Aboriginal people would pay the biggest price, that perhaps the systemic racism that was already in the system and the impact on that, on how these laws would be interpreted, wasn't considered?
I can't confirm whether it was, to what level of consideration these factors have given. I can confirm that these are factors that we give consideration to, in my experience.
It leads inevitably, this discussion, Attorney, it leads inevitably to the question that concerns the Commission and the Aboriginal community in Victoria. How can the Aboriginal community be protected against that sort of decision-making in the future? How do they tell their family and their children that they're going to be safe from a system that is designed to ensure that it's much harder for them to get bail and to stay out of custody?
Look, I think we can go further than just giving confidence by someone like me saying, yes, I consider it. It's part of my philosophy and how I approach law reform. I know that the community expect more than just that. I know I'm not going to be in the position forever. We need to embed it. We need to do better than just consult. We need to have meaningful partnerships, embed self-determination, so that when we are factoring up all of the complex issues that have to be considered when you are changing the laws which impact people's lives, when you are making decisions about who should be incarcerated and who shouldn't be, the Aboriginal Justice Forum often bring the problems to me, and I think in having an open conversation about how we address the changes to bail is a good example of how you can feed in better. How do we embed that through future decisions, particularly in the criminal justice system? I think is something that is incumbent upon all of us to work out how we do that. I'd love Aboriginal Justice Caucus to have the confidence that their views have been given sufficient weight. I hope that I can demonstrate that there is, that it is important to government for their views to be heard. But how do we demand that? How do we make sure that happens? I think that's an opportunity for Justice Treaty, what Aboriginal Justice Agreement looks like next, what the next Aboriginal Justice Forum, how it evolves, how it can be more, have the principles of self-determination more brought out in more examples and more, not an option, I think, is trying to work out how it's not just an option and how it's embedded is something that I'm interested in exploring with Aboriginal partners.
Commissioner, Attorney, I'll put this to you before moving on to the next topic. Aboriginal people in Victoria have been the subject of consultation for a long time, and decisions are made against the interest of Aboriginal people over the top of that consultation on a regular basis. That's the evidence that we've heard, this Commission. There has to be some real structural change to ensure that that doesn't happen, unless there's really good reasons for it. And it's encouraging to hear your reference to a justice treaty and the treaty processes. But I suggest to you that until such time as there is some real structural change, the process of consultation is bound to leave Aboriginal people disappointed. What do you say to that?
Well, I think in the interim, particularly in before there is a structural change, it is my responsibility to ensure that it's more than just consultation. I learn a lot through the Aboriginal Justice Caucus and the stakeholders and the members, and so much so that I just ring casually and test some of my thoughts every now and again, coming back to the point that it's not mandatory for agreement with the Aboriginal Justice Caucus, but certainly value their input, as does the members of my cabinet. I can confirm that.
Thank you. Chair, I note the time. Is this a convenient time for you, or am I...
It is. And we want to have a break?
Yeah.
Yes.
Can I just note also, then we come back, I've just got a few comments on the bail, but I'm happy to break down.
Well, it's 12:30 now. I understand that the Chair has some other commitments to attend to. Perhaps we could just take 5 minutes, Chair, if that's okay with the Commissioners. And
How long have we got to go?
if we only take 5 minutes, we should finish by 1.
I see, and not have to come back this afternoon.
And not need to come back this afternoon.
Yes. Well, let's take the 5 and come back.
I can stay.
Oh, the Chair can stay to 1.
I'm sorry. So you're able to stay, Chair?
It's till 1, yes.
Oh, I apologise. I thought it was a 12:30 departure. Commissioner Hunter, you've got some questions on this issue?
I'm not sure if they're more probably comments than questions. We talk about the bail reform and we talk about Veronica Nelson, but we need to remember that he only appeared to commit to bail reform when public sentiment following the Veronica Nelson inquest was overwhelmingly in favour of addressing the failure in the current bail system. But we need to remember that despite this being a recommendation, this was a recommendation over 30 years ago in the Royal Commission into Aboriginal deaths in custody. And will the recommendations, I guess, of this body that sit under you, will this be another recommendations that sit on the shelf? I worry that it's going to take another death somewhere for other reforms that impact us quite adversely. Sorry, did I make sense in that? So we've had reforms sitting there, recommendations sitting there for 30 years, but it actually takes the death of an Aboriginal person and people to actually see it visually, to see the impact and the impact it has on the community. But something has to happen for reforms. Does something have to happen if we're if you see those statistics of Aboriginal people rising in certain areas, do we have to wait for another death for something to happen? Or will this bail reform be monitored? Will also, I guess, the outcomes that the Day family have pushed for, will they all be monitored so these things don't adversely affect our people and that we are going to get change? I might have gone around the long way there.
Let me start with bail and the changes and how we want to monitor them, for example. Bail decision makers are individuals, and so we're going to have a variety of outcomes, and I want to make sure that we're monitoring those to make sure that we are getting the intended change from our bail reforms. So we're making the tests, we're changing the tests so that it's effectively easier in appropriate circumstances for bail decision makers to not have people on remand. Like they've got a little bit more flexibility, but it's still discretion. So I'm really interested in making sure that we are making sure that is having the intended outcome. And frankly, the intended outcome is less people on remand. Those figures are unacceptably high and disproportionately impacting various groups, including Aboriginal people. And so that is the intention of addressing the bail laws, is to reduce remand. So that will be the indicator of success. But again, it's something that we're very interested in monitoring in real time. It'll take some time to flush through, I guess, in terms of points in time to see how we're going. But that's something that I'm not going to leave for a 2-year review to see if it's had the intended benefit or outcome.
Thank you. And just one on community safety. So we've heard in our evidence and in the coronial inquest of the passing of Veronica Nelson, that community, for us, we feel like community safety is not considered important by lawmakers. So we assume that when governments say they're concerned about community safety, they are more concerned about the safety of white middle class communities. And that's what it feels like to our community.
That's the feedback I get from the conversations I have with Aboriginal people, and I'm learning more and more about that.
Can I just make a comment too? I think that I think we need to remember that the bail reform laws that are being proposed are not sort of a great leap forward. They're actually undoing a terrible injustice that was imposed on Aboriginal people in 2018. So I'm asking, I guess, what assurances you can give commissioners that what gets in its place is not just a reversion to bog standard Aboriginal systemic injustice within the criminal justice system, that is actually better than it was when these laws were introduced.
It's certainly in response to the consequences of the reforms, and so I agree with you. We are returning to a better setting that more appropriately responds to low-level offending that the community actually accept is not a danger to their safety. It's not acceptable behaviour, but shoplifting and the like, of course, should have a consequence, but that shouldn't be remand. And so the intention here is to ensure that people who are not a risk to community safety are treated appropriately, and that means bailed.
What review mechanisms or processes will the state put in place to ensure the reforms work as intended and are effective in reducing the rates of First Peoples on remand?
There'll certainly be review mechanisms because there's a range of data that's available, there's a range of lived experience that we will hear through legal service providers, for example. So I'll firm up exactly what the review mechanisms look like and come back to you on that. at the moment, I want to get the legislation done, but it's, as I said, I'm supportive and passionate about the legislation because I want it to work. So I'm certainly keen to identify opportunities for review. It's probably more a remit for the department. It's not my expertise, but I certainly ask the questions.
That's
So
right.
therefore, making sure that we have mechanisms that provide the answers and that I can be transparent with those answers. It's something that I will probably put as a regular agenda item on my report backs to Aboriginal Justice Caucus, for instance, so that we are continuing to have the conversation to ensure that the reforms are working. And they're pretty good at keep holding me to account, and there was a lot of interest in, okay, that's great, go and do your bail reform, but we want to talk about what more you can do after that. So I think it'll be an ongoing priority of Aboriginal Justice Caucus, which means it'll be an ongoing priority for me.
Attorney, before we move off this topic, you're aware of a request from the mother of Veronica Nelson as to an appropriate name for this reform provision, are you?
Yes.
And is that something the government's taking into consideration?
As I said, the Secretary for Justice has sat down with Veronica's family and talked about some of our reforms. It's, as we've identified, the coroner's recommendations are not all fully implemented in the first tranche of our reforms, and the family's request was that their consideration of their proposal of a name for legislation involved the full suite of recommendations. So it's my understanding that the first tranche may not be captured by that request.
Occam's Law was the advocacy, I think, from the family. Occam's Law.
And so, has a further discussion been had with the family about whether that would be something that they would be happy with?
I'll have to take that on notice about this, where that conversation landed with the Secretary.
You would agree that it seems like a small request in the circumstances?
I want to respond to the grief of that family through action, and the action is the law reform.
Are there any other questions on that topic before we move on? The next topic, Attorney, is the independent oversight of police. You're aware that that the Aboriginal community, through its various advocacy bodies, including the Aboriginal Justice Forum, have been consistently calling for independent oversight of police conduct for numerous years.
Yes.
I pose a hypothetical question. If an independent body were to be created, it's possible that it would be created within the justice portfolio, just as the, administratively, in the same sense as administratively, IBAC and the Ombudsman's office within that portfolio, so to speak.
I hadn't thought it would fit anywhere else, but now you mention it, I'll have a think about it. But I think justice is probably its likely home. Yes.
Yes, well, that's the suggestion. That's where it naturally fits, if I can put it to you that way. My next question was going to be whether you've given consideration to that issue, and in the comment on the last answer, I think you demonstrated that you have given consideration to where it might sit.
I just accepted it would sit with me, but you're giving me room for thought that perhaps it's not, but I think it probably does, yes.
You're aware, are you, that there was evidence before this commission from Mr Maguire and McCulloch in relation to civilian-controlled models of police oversight, particularly the police ombudsman in Northern Ireland, the pony model.
The pony model, yep.
Referred to. You accept that model is one which has the highest degree of transparency?
There are a range of different models. I'm not the expert in which is the most transparent and which isn't, so I don't know the answer to your question.
We did hear evidence from Tamar Hopkins of the Police Accountability Project.
Yep.
About her research and views about the need for external independent police oversight, distinct from a model, the present model, where matters are referred back from IBAC to police to investigate internally.
Yes, I'm aware of Ms Hopkins' evidence.
And you're also aware that in 2022, the Independent Broad-Based Anti-Corruption Commission published a review of police handling of complaints by Aboriginal people. You're aware of that review?
It requested a review, recommendation 61.
Sorry?
The Royal Commission into Police Informants, recommendation 61, requested a review.
Yes, they conducted a review.
No, they asked government to review.
I'll find the document. In that report, there was a finding that, now, I've got it here as 85%, but that doesn't sound right to me. It might be, it's in the 80s. 85% of cases, there was a conflict of interest reported by the investigating officer in relation to matters which were referred from IBAC back to the police.
Correct. Yeah, I'm aware of that statistic.
The conflicts of interest in this setting, I think, it must be largely. I'd ask you to accept a largely circumstances where the investigating officer knows of the officer, the subject of the complaint, in a way that gives rise to some conflict.
Objection. Can my learned friend just make it clear that he's asking the Attorney General to make an assumption to that effect rather than seeking to elicit it as a fact? I'm not certain whether the Attorney General's been armed with enough facts to be able to answer it as a matter of fact.
I thank my learned friend. It wasn't intended to be put as a matter of fact, but in the setting of a police investigating police, where there's a conflict of interest, it's likely that it's going to be in relation to the officers knowing each other, the investigating officer knowing the subject of the complaint.
I think that's accurate. I haven't, apart from knowing the complainant, it's difficult to come up with a lot of other examples of where you would have a conflict.
Purely, Attorney, purely on the basis of good governance and transparency, that level of conflict of interest is really unacceptable. Would you accept that?
It's a complex area of policy. So at the outset, yes, but that's my answer in general. But having an appreciation of what the complaints are may temper that response a little bit. So if the complaint is a customer service-like complaint, like the police officer was rude to me, if that then goes to IBAC and goes back to the sergeant, even though there's a conflict, that might be appropriate to deal with. Even though they know each other, that might be an appropriate way to deal with that particular complaint. But I think you can't apply that logic to a complaint that involves a serious complaint involving physical contact or something. So it's a little difficult for me to draw an assumption on what's appropriate and what's not because I think it's a case-by-case basis, or categories of complaints, which make it difficult to just say yes.
Certainly. Would you, however, accept that for an Aboriginal person thinking about making a complaint about a police officer, if they knew that there were conflicts of interest in 85% of complaints, do you think that would have an effect on their willingness to make a complaint?
I do. And I... Do you want to just keep...
Yes, please.
Yeah, I think my approach to police oversight, and I've been looking at this for some time, so you'd be aware that we have an IBAC model, which you can make complaints to IBAC, and it works in conjunction with... Yeah, you know all the basics. All right, good. The Royal Commission into Police Informants gave a recommendation to government to conduct a review to ensure that you have a better system of police oversight. We have been out for consultation for some time in relation to that. We want to have we know that we need to change it. We know we need to do better. We want to have a more complainants-focused response. But what I have been particularly interested in is how we do better for Aboriginal complainants, and in fact how we do better for Aboriginal people, because we know that a lot of them aren't complainants when they should be, because they are reluctant to make complaints. So as part of that review, which has not come to me as attorney yet, it's still with the department, we had a specific stream of consultation with Aboriginal legal partners and the like, to give us their views of what would be a better system, how can it be more culturally safe. And so when that comes to me, and when we are forming what the first approach to a new oversight system might look like, very